A petition under section 389 that is rejected. Legalized.
May I please proceed? I recognize item number 17 and 18, my lord. And this may be taken after vacation, due vacation.
On the prayer for adjournment made on behalf of Mr.
PK Das, my lord.
P.K. Das, learned counsel for the appellants, which is not objected to by the learned additional people. This is the matter after the vacation.
If you get.
That's why I beg to mention item number 15. 14 is also connected matter.
Who is for who? Acha, 14 and who?
15 were appearing, my
You're Mr.
P. Chaudhary.
On the prayer for adjournment made by Mr. P. Chaudhary. But you're not in 14,
14 there.
I
Yes.
put up.
Mr. P. Chaudhary and Mr.
D. Boraman.
D. Bora, learned counsel for the appellant, which is not objected to by the additional people. This is the matter after the vacation.
After vacation. Deeply. Okay.
Where is the paperwork?
My lord,
Yes.
there's a series of appeal, wherein some of the appeals, our learned senior DK Mr. will be leading. But now the item number 1, my lord, so for the factual part is concerned, my lord, I'll take your lordship to the factual part.
This is arising out of one incident or what is this?
That is one FIR, my lord.
One FIR.
One FIR. Actually, what has happened, my lord? All these, there are 13 appeals here. And initially, there were 19 accused who faced the trial.
Huh?
Who faced the trial.
19 accused.
19 accused, they faced the trial before the trial court. There were another 6 accused were there, namely the charge sheet, my lord. But they absconded and they could not be. So out of these 19, 2 they did not prefer, although they were convicted, they did not prefer appeal. They served a sentence.
No,
they-
out of 19, 6 absconded, so 13 left.
13 left,
13 left.
my lord.
Hmm.
So 2 has not preferred appeal.
So there'll be 11 appeals then.
Yeah. So, my lord, all those, what has happened, my lord?
But are there 13 appeals here?
Yeah. What has happened, my lord? This UNLF,
Huh?
UNLF.
Huh.
Oh, no, yeah.
UNLF.
UNLF, this is a terrorist organization.
Yes.
UNLF, United.
United National Liberation Front.
My lord, that is listed as terrorist organization. It's in the schedule of UNLF, schedule of UAP Act. That is
Give us the UAP Act.
UAP Act at item number 14. Item number 14. That is schedule
Item, 14.
Item number 14. They are declared as terrorist organization under section 21M of the Terror Act. Okay. For the purpose of this act, considering this act, my lord, will require the old, because there are a lot of amendment, my lord.
I have made, your lordship may have
Yes,
seen,
yes.
there are 10 paper books. 5 of them relate to, contains rather exhibits. Then the remaining 5 contains the evidence, chart sheet, all these. And if we start referring to each of the compilations, going to create some difficulty, my lord. Your lordship may be picking up and keeping, and then 2, 3, 4. So what I have done is I have made compilation, of course, of all the necessary documents which are required for arguing. Of course, my case, others I don't know. But since my learned friend says that the old, because matter relates to 2012.
Oh, yeah.
So your lordship will require this UAP Act, which was amended up to 12.
Okay, well, that's all.
But now it has been extensively amended.
Yeah, certain.
Therefore, I have made this 2 compilations. I will send it before.
Yes,
Compilation. Compilation.
no,
This is already written. Okay. ये देना है तब देना पड़ेगा.
Acha, this was, yes.
Now, if my lord will take compilation number 2. I'll just say this and you'll argue that takes that seat. Your lordship will see the index Unlawful Activity Prevention Act. This is the relevant act for this case, which is I have annexed at 1 to 26. This is 2013 edition, contains amendment up to 2012. Then TADA I have given because I'll be referring to some judgment where the provisions are all parameterium with slight change. And also,
Provisions are perimeteria.
yes, TADA is only for, since facts of the TADA will be definitely different, but the law will be similar. With little change here and there, which will not make any material difference. And then below that, the Evidence Act, which contains, my lord, provision for admission of the electronic records. That I have given. So these 3 are there. So here, from here, if you have given a copy to my learned friend also. So if he refers from that, it will be given. So, so your lordship is having 2 compilation, 1 and 2.
Yes.
Have given.
So what I was on my lord?
Okay. Compilation.
Yeah.
Yeah.
Harry. So this organization, my lord, they are declared as terrorist organization under section 2. Section 2, your lordship may kindly
M, 2M.
yeah. Section 2L, yeah. Terrorist gang. M. Yeah. M, mother, section M. Means an organization listed in schedule or an organization operating under the same name as an organization so listed. So by this method, your lordship may go to the schedule. Just these are the preliminary that may come across, my lord, before my friends start, my lord. Schedule. Yeah, my book, my lord, page 27. You'll also find item 14, United National Liberation Front, UNLF. 14.
No, out here, terrorist organization. Out here, item 4.
14.
No, in mine it's item 4.
Oh.
In this compilation that has given to me,
Sure.
that is at page 26. It is that United National Liberation Front, UNLF, is at item 4. Item 14 is Babar Khalsa.
Mother, that is the old act, mother. Old act.
So which edition are you using?
Mother, because this FIR was filed in
Huh?
the incident of 2014 onwards, mother. So, FIR control. FIR control.
Sheet was submitted on 14/2011. 14/2011. So the matter relates prior to 2000.
Submitted on 14?
14/2011. There are two charge sheets, you know. There are two charge sheets.
Which is the other charge sheet?
Mother,
Yes. The second is supplementary charge sheet, which my lord will find, it's I've written dated nil. At page 95 of paper book 1, my lord, this your lordship has to see from the paper book.
Paper book 1,
The paper book 1,
part 1.
part 1, part 1. Paper book 1, part 1. Please keep this.
Page
95. 95. If your lordship permit me, then I'll begin, my lord, otherwise. I find it will be.
The second charge sheet was submitted when?
Second charge sheet, my lord, the supplementary charge sheet, the date is nil. But it was submitted in 2012. Your lordship will kindly take this
When 2012, which date?
date. This is, in fact, my lord, the date is not there. If your lordship will kindly have part 1, volume 1,
Yes,
page 95. Is the
yes, I've got it.
Now your lordship will see date. The date is blank. Then at the last,
second to 28.
your lordship will come to page 129. 129. The last paragraph 23, dispatched on. This was dispatched on 5/3/2012.
One to nine, paragraph 23, dispatched on.
Dispatched on 5/3/2012. Read lordship get. So the date is not there in supplementary, but it was
So it could not have been submitted prior to 5/3.
yes. It was dispatched, so but then if your lordship will come to page 90, the paragraph, page 95 of this same paper book which your lordship is holding.
Page?
Page 95, your lordship come back again to the first page, page
Yes.
95.
Yes.
The FIR is similar FIR, same FIR. 17/9/2010.
Yes.
So same FIR in connection with this only, the
So
first
so
FIR.
what is the relevance?
So the relevance is some of the accused who were not by law.
In the first charge sheet?
The first, they have been brought in. Because the investigating officer was also changed. Earlier it was SP Pani. In this case, it became Mr. Asim Shrivastava. He came, he took over.
So what is the issue basically?
Now, issue basically, I'll tell. My lord, the case that they have made out is that the accused, and this is not only the cases where I'm appearing, but it's all across the board, is saying that the accused are members of a terrorist organization. And they have indulged in terrorist activity. And they have also tried to wage war against the government of India. But the conviction which has been given, conviction and sentence of majority of the appellant before your lordship, relates to section 20, section 18, and section 121 of the Indian Penal
Section 18,
Section 18 of UAP Act, Section 1820 of UAP Act, and Section 121A of the Indian Penal Code. These are the three sections, and one addition is Section 21 in respect of accused number 24. And I may, before I start,
section 21 for IPC for
for
which
accused number 2024.
no, serial number, which
Yes.
is the serial.
Brajo Bidhu Singh, he is in supplementary charge. Brajo Bidhu,
No, where is he? Which appeal?
item number 8.
8. Braja Bidhu Singh.
My lord, I am appearing, your lordship may mark. I am appearing in item 3. I am appearing in item 3, 4, 5, 6, and 8. So I'll give you. If you lordship to see how much conviction they have already undergone sentence in respect of these 5 persons. The first one is S. Rakesh Singh. He is at serial number 6 of your lordship's court, 3 of your lordship's court. He has, my lord, spent total 1 year, 11 months and 11 days. And he was sentenced under section 20 UAP for 7 years, under section 18 for 8 years, under section 121 capital A IPC for 10 years. Then item number 4. Item number, now item number 6, my lord, we should have given it serially.
Just a minute. What is
No,
the
no,
case
no.
number? Just a minute. Rakesh Singh is
Rakesh Singh is item 3
criminal appeal 262.
of 2016. And then number 2, Noren is item number 6, criminal appeal 265.
So, no, wait a minute. This Rakesh Singh, he's been in custody for 1 year, 11 months.
Yes.
He was he has been released on bail
Yes.
after this, during this appeal.
Earlier also during trial also he was an appeal.
When Noren.
Noren Singh at 6, serial number 6. Criminal appeal 265 of 2016. Noren is accused number 8. Then your lordship will come to accused number 11. This is
Shinam Gunesh Singh.
that Gunesh Singh is item number 4, 263. Criminal appeal 263 of 2016.
So all these sentences are to run concurrently or
Yes, yes,
consecutively?
concurrent. If your lordship will kindly see serial number 2 and 3,
Ah.
their maximum sentence was 10 years. They've already served 7 years.
Hmm.
2 and 3. Then Moniton was 5 years. he was there and he was to serve 7 years. He is convicted only under section 20. He's at serial number 4 of this paper which I have given in lordship to see. And Brajabodhu Singh, 7 years, he has already served 5 years. So these are the gist, my lord, of the conviction already undergone. And
Okay, so now,
now, if your lordship permit, I'll begin with 6.
begin with 6.
Yes, accused number 6, serial number 3.
Appeal number 132.
Appeal number 262 of 2016.
Yes,
My lord, accused number 6. He was arrested, my lord. on-
why do you say accused number 6? From where do you say accused number 6?
Oh, it's in the judgment.
In the judgment, oh, you're going by the judgment.
And that is how accused number, they have been referred.
They have been referred, but you have not put that in your chart. So we have got 3 different,
Your lordship will see the chart A6 after the name.
okay, A6, okay,
Yes, and those accused numbers, they're there.
yes.
And then if your lordship will kindly turn to page 57. Page 57, if my lord will kindly see.
Yes,
The relevant is at page 63.
57 is the charge sheet.
Yes,
The first
original
charge sheet.
charge sheet, the first charge sheet. First charge sheet, and this is dated 14/2/2011. 14/2/2011.
Yes,
Now, if my lord will kindly turn to 63, page 63. Serial number 6,
yes,
the name of the accused, Saujan Rakesh Singh, herein after referred as accused 6.
yes,
Never got it. So that is how I'm referring to them as 6. Now, this Rakesh Singh was arrested, accused number 6, under section 120B. 121A, 121, 122 IPC, and section 16, 17, 18, and 20 of UAP. But he has been convicted, as I said earlier, under 3 sections, 18, 20 of UAP, and section 121A of IPC. Now, the sentence under section 18, accused number 6 has been sentenced to undergo rigorous imprisonment for 8 years. And under 27 years, under 21A, 10 years, and fine will be all 10,000. And in deferred 1 year, that's common to all these. Now, if your lordship will just to have an idea what was the case, I refer to the first charge sheet at page 57 of volume 1, part 1.
yes.
It's long charge sheet, but I'll refer only what I find melody is relevant. So I'll take your lordships to 77. page 77. On the basis of a reliable input about presence of active members of proscribed terrorist organization United Liberation Front, hereinafter referred as UNLF of Manipur, at the rented house of Y. Naveen Chandra, alias so-and-so, a raid research was conducted on 30th April 2010 at 8:30 p.m. by the complainant of this act, Shri Trilokya Barua, SI City Police Reserve Guwahati. During the raid, 2 persons were identified as so-and-so, and Nokia mobile and other things were seized. Subsequently, as a part of the same conspiracy, more accused persons who were members of the proscribed terrorist organizations were also arrested by Assam police on 3 different occasions, and the item including but not limited to pen drives, laptop, mobile phones, Indian currency was seized from their possession in presence of witnesses. Then the name of the witness, accused persons are mentioned in 16.1. Your Lordship will see 16.4. Since the aforementioned case unraveled, criminal conspiracy hatched by the accused person as a member of terrorist organization, that is UNLF, to wage war against the Union of India by committing or attempting to commit terrorist act, raising funds for committing terrorist act and attempting terrorist act by involving different places within and outside India. Central government, Ministry of Home Affairs, found that the offences are scheduled offences as defined under 2G of the National Investigating Agency Act 2008, thus in exercise of power conferred by so-and-so. The National Investigating Agency Act directed NIA to take the investigation. Now, my lord, the main, it starts from 17. In the instant case is registered against the members of proscribed terrorist outfit United Liberation Front, involved in criminal conspiracy to wage war against nation by indulging in fundraising, heinous terrorist act, and threatening the unity, integrity, security, and sovereignty of India. My lord, I'll pause it here for a second. The conspiracy is to wage war against the country. None have been convicted under 121, which is a provision in the IPC for waging war. And by indulging in fundraising and heinous terrorist act, not a single terrorist act is subject matter of the trial. Not a single terrorist act, my lord. There is no allegation that there were injury, some injury was caused and some property were damaged. Rather, there is a finding which has of course surprised me, that there is no terrorist act. And just few paragraphs more, then I'll go straight to the point. The UNLF is a terrorist organization, is involved in several violent incidents of maiming, murdering, kidnapping, etc., etc. On Manipur, during the course of investigation in the entire case, detailed 149 violent incidents as committed were obtained from lawful retrieval, email, communication, accused persons, further FIR in 29 cases. All these they are attributing to UNLF that was done in Manipur, and they have obtained, but they have not investigated. Then Then they are saying, UNLF has been involved in procuring highly sophisticated weapons to wage war against the India. All these are there, nothing has happened. Now, specifically, my lord, I'll take your lordships to the allegation against A6 at page 84. At page 84. In pursuance of the said conspiracy, accused S. Rakesh Singh, A6, on the direction of the other conspirator in the instant case, has carried out activities of the UNLF in form of disrupting supply of community life in India, blockade of NH-39 by threatening unity, integrity, and sovereignty of India. A6, apart from their being regular touch with other co-conspirators, has arrested in the instant case, guided and fostered criminal conspiracy to wage war against the nation. A6, because of his educational background and proximity to the top echelon of UNLF, conveniently carried out the objective of UNLF of waging war against India by raising clandestine transfer fund to UNLF. Now, it could be as vague as it can be. Now, in the second charge sheet also, at some places, my lord will kindly turn to page 117 of the second charge sheet. Hmm. 17.5. One 117, your lordship got no. It is typed at two places, same page 116 and 117. Similar thing has been typed at two places. During further investigation, the facts about Rakesh Singh, accused six. During the further investigation, the facts about Rakesh Singh, accused 6, came on record, which discloses that in pursuant to the criminal conspiracy later part, R.K. Megan, A19, sent Rakesh to London for coordinating the business of UNLF. He was sent undercover for pursuing the course of the computer engineering in London. UNLF funded Rakesh A6. UNLF invested huge amount of money in various business venture in UK through Rakesh Singh. In the year 2006, Dr. Mukul, UNLF, and one more person from Bangladesh incorporated a company, Southeast East Asia Conglomerate Private Limited, located at so-and-so place. Rakesh Singh was nominated by R.K. Medan as one of the director of the company. There is not an iota of evidence. He has not been convicted also. So then, my lord, will all these allegations are there. I need not take. I go straight, my lord, to the conviction part. And my lord, my submission will be based on technical point. Because the main allegation is that they conspired to wage war against the country. That's the main allegation, and pursuant to that, they did this, that. So, and what are the specific allegations? Is that it disrupted the supply of the community life. Well, he was associated with the students, and in this part of the country, my lord, I have seen there are called Bandh. Now, every Bandh cannot disrupt the community life, and it will come under UAP Act. These are one to register protests. Then road blockade. Then he says proximity with top echelon of A6. Then carried out objective of UNLF like waging war against the India by arranging clandestine transfer of money. So he has been convicted, I have said earlier. No. He has been convicted under 18, 20 and 121. My lord, I'll take your lordships to section 20, because 20 will take time. Others will not take time. 18 and 121 will not take time. 20 will take some time because and this is also on technical ground I have challenged. As well as, of course, I'll refer to those specific emails which attributes something to me. So 20 will take some time. If your lordship will come to 20, your lordship will find at the compilation that I have given. Compilation 2. Page 13. My lord, punishment for being member of a terrorist gang or organization. Any person who is a member of terrorist gang or a terrorist organization which is involved in terrorist act shall be punished with imprisonment for a term which may extend to imprisonment for life and shall also be liable to. Now, similar provision also existed in TADA, and your lordship will find at page 27. Just compare, then I'll proceed with the ingredients.
Page?
Page 27, relevant, I'll just give my lord. My lord will come to 29. One is, my lord, the punishment for terrorist act and what is a terrorist act is mentioned there. If your lordship can come to subsection 5 of section 3 at page 30. 30 of that. Any person. Now this and 20, your lordship may look into both. Any person who is a member of a terrorist gang or a terrorist organization which is involved in a terrorist act shall be punishable with imprisonment for a term which shall not be less than 5 years, but which may extend to life. Now the conditions, ingredients of both sections will be same. Your lordship has said this is verbatim reproduction of section 20. Why I'm saying is because I will take your lordships through Kalpanath Rai's case, where the ingredients of section 20 are given. What are the ingredients of section 20? So, my lord, there are two ingredients of section 20 at page 13. First is that the accused must be a member of either a terrorist gang or a terrorist organization. Now, my learned friend has already taken your lordship about terrorist organization. It is defined under section 2L of the UAP Act, which says that the schedule contains the person included in the schedule will be I'll just place it below. Terrorist organization, my learned friend says aim, terrorist organization means an organization listed in the schedule of an organizing or an organizing operating under the same name as organization so listed.
Where are you reading?
My lord,
Where are you reading?
2L page 3 of the UF.
2M,
L, 2L page
Pa-
3,
page 3.
2L
2L.
means an organization listed in the schedule or an organization operating under the same name as an organization so listed. My lord got it. M.
Of Tata
No.
No.
3 is
or
UAP.
UAP Act?
Yes, UAP. Tata I have referred only for 5
Okay.
because it is parameteria with section 20. Terrorist organization
Yes,
2M.
terrorist organization.
Yes, terrorist organization means an organization listed in the schedule or an organization operating under the same name as an organization so listed. And if your lordship will see page 26. Page 26 is the schedule appended to the UAP Act. And your lordship will find 4 United Liberation Front, UNLF. Now their case is that we are member. Like you are United UNLF. Oh, okay, this is weak edition. You see 2000, give him 2030. 13 edition is the compilation. What is there? He must have bought it from second-hand bookstore.
No, that is what we studied.
See, take this.
That is what we have
13 edition. 13 edition, you see.
Whether it's second-hand bookstore or from a first-hand bookstore, it's the book, it's the same thing.
No, sometimes, my lord, different pages are next. This is also like that. Immediately. Well, fact remains it is there. Whether it is at 4 or
It is in the schedule.
it is there. It is in the schedule. And nobody can dispute that UNLF is not a terrorist organization as per the definition. Because it
So
is,
if it is a terrorist organization, won't it ipso facto mean that they are involved in terrorist act?
yes, of course, that your lordship is coming directly to the point. And as I have said, no terrorist act. It is a finding of the court.
No, no.
No terrorist act. Finding of the court. I'll show.
Finding of the court is that
Finding
the
of the court.
finding of the court, the
Yes.
trial court,
Yeah,
is that there is no terrorist act.
Yes.
However, the very fact that they have been put
Section 20.
under
No,
section
I-
20 would require some material. And that material, I think, would be there, I think, should have been there.
Nothing is there. I'll take your lordship through. Your lordship, I'm sure, as I was surprised, your lordship will be surprised. Because my lord, somebody says that I'm a member of UNLF. Mr. Das says that Mishra is member of terrorist organization. I not become unless he shows something.
No, leaving that aside,
My lord.
the issue is, I think, UNLF is a terrorist organization.
Yes,
That is not disputed.
yes.
The only thing you are disputing is that UNLF may be a terrorist organization, but you are not a member of that.
Yes.
That is your case.
Yes, and what is the evidence on the basis of which they say that I am a member of terrorist organization? If
Have
they
you-
have evidence, I'll take your lordship through. Then they have. a-
So there is no dispute with the fact that UNLF participates and
That
acts.
I'm not saying.
You're not saying, but no, but I
He
mean,
is, it's a terrorist organization
Okay.
as defined under section.
so you're not going into that territory.
Yes.
But anyways, so the only issue that you're going into is whether you can be termed to be a member, you can be identified to be a member of that organization. That's all.
So now the second, I have come to second 20, your lordship will see the first expression is whoever is a member of a terrorist gang and a terrorist organization. Terrorist gang is defined in 2L, just above M,
Yes,
at paragraph 3 only. Page 3 only, sorry, of the
yes.
terrorist gang means any association other than terrorist organization, where systematically or otherwise, which is concerned with or involved in a terrorist act. So if a person is charged under section 20, two things will have to be proved. One is that he is a member of a terrorist organization and he or his association, terrorist organization, is involved in a terrorist act.
Yes, the association is involved.
These are required. Here
So,
there is
so the only thing they have got to prove is whether you are a part of that organization. That's all.
yes,
Whether you are a part, whether you had participated in a terrorist act, that is not the issue. That is only an issue to be decided with regard to the organization or the gang.
well, this Supreme Court says that both, because suppose 10 persons
Yes.
get together, it will be an association.
Hmm.
And they go and commit terrorist act.
Hmm.
So they will be responsible.
No, correct. But supposing there is an organization.
Now there is an organization, and if
And let's say 1,000 persons are part of that organization.
Yes.
If only 5 of them do that act,
so therefore,
so the 5 of them had done the act, but the other 995 persons,
Yes.
they're still part of that association.
there has to be proof.
That is
It's
a
not-
different issue.
Yes.
Proving is a different
Yes.
issue.
So if a person is a member of a terrorist organization, then that organization, there should be evidence that it has participated in the terrorist act. Just because it's listed in the schedule will not do.
But that is not your case, no?
Yes. My lord.
It is not your case that UNLF is not a terrorist organization.
No, that is not my case.
Correct.
But
So if
when-
that is not
when
your
I
case,
think-
so it is a fact that they are involved in terrorist activities.
No, that is not a fact. That is just a, my lord, it's a, how the schedule is made. Schedule is made by an executive authority, by
Anyway,
Union of India.
those issues will have to be decided in a writ petition or something.
No,
Where
here,
the act, where your inclusion in the schedule is challenged.
my lord, I'm not, no, I'm not included. Nobody is included in the schedule. The question is whether terrorist organization is involved in a terrorist act or not. Suppose they say I'm member of the
No,
terrorist,
no.
then whatever that,
I think you're digressing from the point. That is not the issue. The issue is whether you are a part of that organization. That's all.
I'm a member, we can begin with that,
We'll have to see whether you are a
member of the.
member of that organization. That's
Yes,
all.
and that organization has involved in a terrorist act.
No, that, you
That
see,
cannot be
you
general.
see, no, because then you have to challenge your inclusion in the schedule by way of a different for.
No, that
different
the
procedure.
organization will.
Ah.
The organization will, I have nothing to do with that organization. But merely by saying that so and so is a member of the organization, and therefore here, my lord, in any case, a terrorist act has to be part of the trial, subject matter of the trial.
Not
or without-
exactly.
Then membership, near a
They
membership.
will only have to show that, we'll see that.
Now that will
Let
be-
us, let us leave
I'll
that
proceed.
issue
All right.
separately.
Yes.
Let us first,
Now kindly see 38. Kindly see 38.
30,
38 at page 17,
17,
117.
38, yes.
My lord will kindly come to 18, sorry. It's 18. offenses relating to membership of terrorist organization. A person who associates himself or professes to be associated with a terrorist organization with intention to further its activity commits an offense relating to membership of the organization. So membership of an organization will be on different footing. But if someone says that you are involved in a terrorist act, under section 20 specifically, I have been charged. My organization has not been charged. I have been charged that I have indulged in these. So then every member, whether he is involved or he is not involved, every member will be, then your lordship will come to 40. 39 is giving support to terrorist organization. 40 is offenses raising fund for a terrorist organization. So a person commits an offense raising fund for terrorist organization with whom he intention to further the activity of the terrorist organization. So I'm only saying this specific case is that I have indulged. Being a member of terrorist organization, I have indulged in a terrorist act. And my organization also indulged. May I just take your lordship just to clarify one decision, which your lordship will get here only. Page 75, Kalpanath Rai. 175.
Page 175.
Page 75.
Page
This
75.
is 9 of this part 2 compilation. which your lordship will go.
Page 75. Yes, Kalpanath Rai.
Your lordship will not remember. Kalpanath Rai was a minister. He fell apart from Narasimha Rao during Harshad Mehta's case.
Okay.
And he was involved in this. So there are other persons also. Correct. Madam, kindly come to page 90. 90. This was the case of Tata,
Ah,
paragraph 34,
yes.
subsection 3(5). I have taken your lordships through section 3(5), my lord, of Tata.
Yes.
If your lordship,
Which according to you is parameteria to 20.
your lordship can see at page 30 again, if required, of this. Tata, page 30. So I'll place 34. Subsection 3(5), inserted in Tada by Act 43 of 1993, which came into force on 23/5/1993 under Article 21 of the Constitution. No person shall be convicted of any offense except for violating a law in face of a time.
In force. For violation of a law in
Law.
force.
Yes, for violation of law enforced, because Article 21 has come, 20 has come. At the time of commission of the act charged under, so it is not enough that one was member of a terrorist act gang before so and so, 23/5/1993. Because that particular 3(5) was inserted after.
So this is pertains to a period prior to 93.
3, yes. Then 35 years old.
Yes.
There are two postulates of subsection 5. First, the accused should have been a member of a terrorist gang or terrorist organization. Both are mentioned here. After 23/5/1993, of course, this date is not relevant in our case. Did I? Did not. There are two postulates of subsection 5. First is that the accused should have been a member of a terrorist gang or a terrorist organization after so and so. Second is that the said gang or the organization should have been involved in the terrorist act subsequent to 23/5/1993. Unless both postulates exist together, 3/5 cannot be used. Tata have given it is. Oh, all right, all right. Yes,
It's a problem, 20 pages here, I'm reading here, then you have to.
actually, for that reason, I made this compilation.
No, no, I understand. I understand the reasons why you did it. I'll bring them. You get the old one also, the new one also. Kalpana,
Judgment.
from 29th of this month,
Right.
both of you sit here, huh? From 29th. I think this matter will take the whole day.
Yes, yes. They not only today, my lord, similar matter we argued before court number 1 the other day. We took 15 days.
How many days?
There were 13 appeals there, 15 days it took. 200 pages judgment, all acquittal.
It's a 24 days.
200, 21 days, I'm corrected.
21 days you will argue. We are hoping that we will not take that long. Not even 1/4,
Here,
not even 1/5. Hopefully we'll finish by tomorrow
my lord,
or today.
there is some health issue with me. I will not be able to continue like this. So that of course subject to your lordship, your lordship.
No, we are willing to finish it up. Only thing is that I want to know the time period, how long will it take? So that I am mentally prepared.
I'll take, I should take, my lord, little more than 1 day.
1 day,
A little more than 1 day, maybe this spill over.
1 day.
Yes.
How long will you take?
Time to many of the arguments have been decided.
So,
On the facts are like,
okay, only that. So they hardly say half a day or something. Not maybe to 1 hour, 1 hour, 1 to 3 hours. Okay.
like local mile run scenario couple.
We are thinking that we'll come after Bihu and
After Bihu?
that is what we are.
No,
After
no, no,
getting
no, no, no,
Not that much. I'm not serious, Manoj.
no, no.
Because-
What I'm saying is that, you see, if we're going to do, we're going to do it continuously. I'm not going to leave it in parts. Because if we leave it in parts, then it becomes again that.
It'll remain in part.
I don't know.
But it depends on the appellant.
Okay, hopefully, Mr. DK Mishra, you'll finish it by today.
I'll try.
The 6, make it.
I'll try.
You've got item 16
Supplementary one.
and you've got 19 also. 19 and the report hasn't come, no? Just give me the 19, we'll just pass the order. Just give me we'll just pass the order. We'll just pass the order in 19. No, 19 does not say that.
Supplementary method, my God, before very.
That is not 19. Supplementary matter is item, it's a different item. 23. Just right in the item 23. The report of the learned trial court has not heard the counsel for the parties, as the report of the learned trial court has not been received in terms of the last order of this
Yes.
court. list the matter after the vacation.
Smile.
That's all.
Debut.
Item 23. Okay, give a date. No, no, no. Give after that,
After,
after. 30th.
obliged.
Then item 19. Um. Item 19, what do we say?
Lordship,
Where's the council?
my probably by now, please.
The eyewitnesses, I think, of the,
Yes, yes, sir.
correct?
Yes. Based on time declaration.
Huh?
Based on
Time
time
declaration.
declaration.
Today is Tuesday.
Yes, Lordship,
Hopefully this will end by tomorrow.
yes.
I don't know.
After Bihu, Lordship, I fix.
You? Correct, on, list the matter after the bill. How list the matter on 30th.
38. Obliged.
19th. Yes, I think, no, yeah. Let him continue, or
Give
you,
it, give it, continue.
yes,
Give it, continue.
yes,
The one proposition which has come from your lordship. That once they prove that you are member of a terrorist organization, then they need not prove terrorist
ah,
act. So any member will be hanged. If he is proved that he is member, whether he has participated or he has not participated.
good, yes, yes,
This is what your
yes, yes,
kindly come to 15 and 16
of the
of the UAP.
EAPI.
Imagination. Actually, my lord, I'll tell your lordship. There is an order by this, your lordship, High Court. Of, dated, 4/8/2023.
In here, in this,
The 4/8.
in which,
In this, in
this batch?
in all, it's common order, it is.
4?
4/8,
Yes, I've got it, yes,
your lordship has seen that.
yes,
Now, we filed an application before the court that these are the emails which though find place in the judgment have not been given to us. It was not part of the exhibit. So it is not part of the,
yes,
so the court directed the registry
yes,
to make the paper book.
yes,
The registry has given us paper book.
yes,
What they say is, the registry note there, 1/9/2020. There is office note.
yes.
Martin,
There is the office note.
like for us.
Huh? Ah, this one, no? No,
I don't like it.
this one, no. No, must be in the item 1. Just look at item.
Item one.
Item 1. No, this is item,
3.
165. Is item 1, correct. Item 1.
I think.
No, no, I saw it, I saw that. I saw that also somewhere.
You take this, we have extra copy.
No, no, I've got the order. The order is with me.
Office
Office note. It is 1923.
1920.
Yes, I've got it. Yes. Yes,
I'll place this order. Ma'am. As per Honorable Court's order dated 4/8/2023, the LCR is newly verified. The list containing the missing exhibit is abstruse in the sense that it contains exhibits that are totally in Manipuri dialect and not in translated form. As such, these were not included in the earlier paper book. The list contains some exhibits which were given in part 1 of the paper book that were already furnished to the Learned Council of both the parties. Moreover, some exhibit lists in the, some exhibits given in the list are not even part of the original scanned copies of LCR. And some other exhibits contain annual balance sheet where date and amounts are in English. But the subject on which the amount is utilized is in Manipuri dialect. Hence, also are not included in the earlier paper book. In view of above, only few exhibits which are in English were left out in the earlier paper book are now included in the supplementary paper book. Further, a list showing exhibits that are either in Manipuri dialect and or contains major portion in Manipuri dialect and a small portion in English that are not included in the supplementary paper book along with the page number of the scanned copy of the original LCR reflected in so and so. So they have given us some they have not given. Why I have placed this order is, we were expecting
Yeah. Just a minute for 19. You're ready for today? No. Why did you come? Okay, make it 6 for it.
No.
6. 8, okay, 8. Yes,
So therefore, having seen that 1/9/2023 order, we were expecting that this will come in orders and then a date will be fixed for hearing. That's what I was instructed. So all of a sudden, I was told it has come. So hurriedly we have prepared, only yesterday we have prepared. Therefore, there is some hesitation, but I will not ask for time. And my endeavor will be to go ahead.
complete. Very good.
Yes. Now, my lord, as I was saying, merely being a member of a terrorist organization will not fasten me with the liability of the terrorist act which are committed by the because if it was so, the provisions of section 15 and 16 of the UAP Act would have been differently worded.
Section 15 and 16.
60, that I'll be referring. Okay. And I have referred already.
Yes, 15 and 16. There are
Yes,
6.
but I'll take the lordship through that. I've also referred already section 35 of the UAP Act, which is
No, you have
provides
referred
for
to 38, not
38,
35.
38, which provides other punishment for being a member of the terrorist organization with intention to further its activity. So suppose a person is a member of terrorist organization, he can also be charged with an offense for the membership. Otherwise, what has come from your lordship, that if you are a member of the terrorist organization, and the terrorist organization is listed, so no dispute that they are committing terrorist act, so you will also go. That, with great respect, my lord, may not have been the intention of the legislation. Because these are physical, these are, my lord, criminal, penal in nature, so it has to be construed very strictly. Very
So,
strictly,
So now, if that be your argument,
yes,
38
yes,
is slightly different from 20,
yes.
slightly different from 20.
It's not different.
It
It's an offense punished, providing for membership of the terrorist organization.
In 20, in 38, In
That-
38, it provides that who associates with it
Yeah, on your lordship.
with an
this is-
intention to further its activity.
Yes, see the heading,
Ah.
is part of the section, offense relating to membership
Ah,
of a terrorist organization. So if what my lord, with all respect, but your lordship says that if you are a member, it is proved, then you will be liable for the act of the terrorist organization. That it's a very broad,
correct,
it's very broad.
correct.
And that kind of interpretation, with all respect, cannot be given, my lord, either in a penal institute or a physical institute, statute. It has to be strictly constituted. So I'll come to 20 again. I'll try to, because I don't run away. I'll try to convince.
Let us go to 15, 16 also. first.
Yes,
15, 16 first.
my lord. The 15 is at page 10 of the combined.
Yes,
Terrorist Act. Whoever does any act with intent to threaten or likely to threaten the unity, integrity, security, or sovereignty of India, or with intent to strike terror or likely to strike terror in the people or any section of the people in India, in any foreign country, by using bomb, dynamite, or other explosive substances, or inflammable substances, or firearms, or other lethal weapons, poisonous or noxious gases, or other chemical, or any other substance, whether biologically, radioactive, nuclear, or otherwise, of a hazardous nature, or by any other means of whatever nature, to cause or likely to cause death or injury to any person or persons, loss or damage to or destruction of property, or disruption of any supplies or services essential to the life of the community in India or in any foreign country. Damage or destructions of any property in India or in a foreign country used or intended to be used for defense of India or in connection with any purpose of the government of India or any state or any of their agencies, or overlaw by means of criminal forces or show criminal forces, or attempt to do so, or cause death to any public functionary, or attempt to cause death of any public functionary, detains, kidnaps, or abducts any person, or threaten to kill or injure such person, or does any other act in order to compel the government of India or any state government or the government of a foreign country or any other person to do or abstain from doing any act, commits a terrorist act. So whoever, it's coming, the punishment, if your lordship will see, whoever commits a terrorist act shall, if such act has resulted in death of any person, be punishable with death or imprisonment for life, or also be liable to fine. In any other case, be punishable with imprisonment for a term which shall not be less than 5 years, which may extend to imprisonment for life, or both. Now, therefore, my lord, these two sections, first of all, 15 defines the expression terrorist act. So an act is committed. The first of all, it has to be decided by the prosecuting agencies whether it constitute a terrorist act as defined under section 50. Then comes whoever is involved. Now, otherwise, somebody shows that he is a member because he has met them or there is a photograph with them, then he will be
no,
hanged.
that is a different issue. Photograph and all is a different issue.
No, that's an evidence of a membership. They can say, they have said here, they are relying on the photograph.
No, supposing
Yes.
a person says, yes, I am a member of that organization,
Yes,
but I have not myself per se committed any terrorist act personally.
no, it will,
Then what happens?
no, it will not be 149 will not come here. 149, whether a person is there on the spot or not, the moment he is member of an unlawful assembly,
149 of what?
IPC.
IPC, just let me
Yes.
see.
There is difference between 34 and 149. Every member of an unlawful assembly guilty of offence committed in prosecution of common object. The offence is committed by any member of unlawful assembly in
This is
prosecution.
slightly a different issue.
Yes,
Basic-
that's what I'm saying is, my lord, it's a passing
No,
reference.
no, what you see, this is, please understand, this is only searching questions. I have
Yes,
not,
yeah.
because I have got to understand the issue.
I also, my lord, we get educated.
Ah.
When we hear, my lord, the questions and
Ah.
try to satisfy your lordship, in the process, we get educated.
No, no, so if there is a separate provision for a terrorist act and a separate provision for being a member, then where is the requirement if both the ingredients are supposed to be inbuilt to come to a finding that he can be prosecuted under this act? Where is the requirement
My
of
lord,
having
My lord,
the
suppose,
two different provisions?
Yes. suppose, my lord, a person, it is proved that he is member of terrorist organization.
Ah.
Then something has happened. He is caught. Now, what will be required? Number one, whether that terrorist organization was involved in this. Not because his name is included in the schedule. Therefore, any terrorist act which has been committed can be attributed to the terrorist organization. There has to be evidence that so and so terrorist act is involved, terrorist organization is involved. It will not be that because he is in evidence, he is in the schedule, therefore anything, yes, you are in the schedule, therefore you have committed it. What act was committed? This is first. For prosecuting, what act was committed is a must. What terrorist act was committed?
No, for coming into the schedule in the first place, that is the requirement.
That is requirement of executive. That's by executive. Your lordship will kindly see.
Has that been put to challenge that this
No,
UNLF is not a terrorist
Well,
organization?
it is not required. Just by putting in the schedule, no one can say that so and so terrorist act is committed by. This is a generalized thing.
And-
No, there is no trial before putting this. There are
Correct.
government puts it.
But then it is subject, it can be challenged.
That can be challenged. Though, since
And if you do not challenge it, it doesn't
that
mean
the
that you have
terrorist
accepted it.
organization itself will be responsible. Not they say you are a member, then you are responsible. Kindly see, my lord, how this schedule has been.
Yes.
Kindly see page 20.
Page 20.
Schedule 26
Yes.
of the same. Kindly see how it is made. Just come below, my lord.
Yes,
Inserted by SO. It is a
Yes.
supplementary order. It is an executive. If there is a report that this organization is involved, then they include it. There is no judicial pronouncement, there is no judicial adjudication before declaring an terrorist organization as a terrorist, including in them in the schedule. It's not through judicial process, it's supplementary. One undersecretary will put it.
naturally, it cannot be under judicial
So
process.
therefore, if there is an allegation that so and so terrorist act is committed, then that terrorist act has to be proved. Link has to be established, then only say, yes, so and so has committed. Now, to cut the matter short, I find that I should take your lordship straight to the finding of the trial court on this point. That will be. Your lordship will take volume 5. Part one. That will, my lord, finish this.
Paper book, part 1.
Part one, yes, 5.
Part one, volume five,
volume five.
volume five.
Part two contains only exhibit.
Yes, page.
Page 990. The judgment starts, my lord, begins at page 948. And I'm referring paragraph 84, which is at 990, only on this point, my lord. It was argued on behalf of the defense that there were no trace of any material against accused under section 16, 17, 16 I have just said, punishment for terrorist act. 16, 17, 18, 18A, 18B, UAP Act. Section 16 of the Act provides for punishment for committing terrorist act. Terrorist act has been defined under section 15 of the Act. On appreciation of evidence as done in the preceding paragraph of this judgment, it appears that indeed there was no conclusive proof that accused committed any terrorist act. There was some evidence that extremist organizations, the Lordship will see extremist organizations, where there are so many, 5, 6 at that point of time, did some violence in Manipur, but that would not prove commission of any terrorist act by the accused who are facing trial in this case. There was also no circumstances and records to show any specific terrorist act was committed on the direction of the leadership of UNLF. Then they all were acquitted under 16.
This is under 16. What about
Yes.
20? What has he said about 20?
20, there is no finding at all. Straightway, they are members, so they have been punished under 20. I'll take your lordship when I am proceeding. It is just for the time being to satisfy your lordship that just being a member of a terrorist organization, assuming the terrorist organization is listed in schedule. Now, any terrorist act committed, can that terrorist organization's member?
No, that person, you see, that the person can be convicted for some specific acts which he does. For that, there's a separate provision under 15, 16.
Yes.
But for being a member, it appears.
So that separate provision is there under 38 I have placed.
Hmm.
Punishment for being member.
But for being a member,
20 is involved in terrorist act. So without proving that so-and-so terrorist act, so such organization is involved and I'm part of it, there's no question of proving. Because there is a finding I have said, there is no terrorist act. Because if 16 goes, 20 cannot remain.
okay, then
So, having, my lord, answered the question that put by your lordship to the best of my capacity, I proceed further. So I was submitting, my lord, section 20 has 2 ingredients. Number 1, accused must be a member of a terrorist organization. In this case, or a terrorist gang, but we are concerned with terrorist organization. This is the first. Second, accused must be involved in a terrorist act or terrorist organization must be involved in a terrorist. So terrorist act will have to be proved. In order to prove, bring home a charge under section 20.
yes,
Your lordship, I'll place now how the charges were framed under section 20. My lord will kindly take part 1 on volume 1. won't be there in the compilation.
Compilation.
It is not there in the compilation. Few things are here.
Okay, part one of volume one.
Volume one.
No, it says compilation is not there.
We have just part one.
Well, I think it's not enough.
It will be like this, something like this.
Yes. Want to take your time.
Your Lordship, the relevant section 20 charges are at page 138.
Yes.
The last charge on this page.
Yes.
Because when I'll these charges I will, my lord, read separately when I come to the sections. So now we are on 20. So the 20, sorry, is at page 39, my lord, the last charge. 139.
139.
Yes. That, my lord, that you being a member of terrorist organization involved in a terrorist act in the foregoing head of charge in the fifth head, thereby committed offense under section 20 of Unlawful Activity Act within my cognizance. And I'm not concerned with 16, but 16 also I will show, because I will not be arguing 16. They have not been punished. 16 is at page 138, the fourth charge. That you being a member of United Nations Liberation Front terrorist organization did terrorist act using grenade, bomb, explosion, injury to person, damage to property, kidnap, abduct, thereby committing an offense punishable under section 16. No offense, as I said, no terrorist act is subject matter. Not a fly die. Nothing. No damage to property, nothing. Just like that, they're free. And 20, here everyone is acquitted, and 20 says you have involved in terrorist act, and then is punished under section 20. I'll first deal with the first ingredient, which says that I'm a member of terrorist organization. What are the evidence on the point? Well, so far as the accused number 6 is concerned, this finding that he is member of a terrorist organization is based on emails, electronic mails. Emails.
Yes.
As well as the statements made by PW9, 17, and 39.
PW 9, 17, and 39.
And 39. There are two more witnesses who are employees of PW 39. their statement is there, but they have not been discussed in the judgment. They are,
Which is to the effect that,
no, they say that some Kachar registers were there, Kachar loose sheets were there from where they show that Rakesh, we have returned some money to him.
so the employees of PW 39
Yes.
are also against you, statements?
They have, but they have not been relied upon. They've not been discussed in the judgment.
No, no, were they prosecution witnesses?
Yes, yes. You
Number?
are PW 61
61,
and PW 63. I will take your lordship. Even though they have not been relied.
not relied by trial court.
61 and 63, not even referred, not relied.
Why?
Not even referred in the judgment, and they have not also been relied.
Why?
61, that trial.
That is against you.
No. Nothing is against me.
Okay, so 61 and 63 are
I,
not
my lord,
against you.
I have a habit, my lord, if I read something, I tell the court. And I also say, I will take your lordship, but it has not been relied. It helps them, or all of us now.
Yes, it helps all of.
My lord, the main dependence of the trial judge as well as the prosecution is on the basis of the other emails. On the basis of emails which have been said to have retrieved from disclosure statements made by accused number 18 and 19. Okay. So it's based on that.
Retrieved from where?
Well, retrieved from the computer, which no details are given, but it is said it's in NIA. And also CSFL, Chandigarh. CFL.
Disclosures made by PW 18 and
18 and 19. Accused 18 and accused 19, not people.
Acha.
Accused. Now, I'll just show that if the email goes, the whole case goes. The first point. Kindly come to the judgment. I'll proceed that. Volume 5, part 1.
Volume. Volume 5, part 1. Yes.
Page 974.
Yes.
All the emails had attachments retrieved on the voluntary disclosure of email IDs and passwords by A18 and A19 revealed the activities of UNLF and its members, some of whom are accused as discussed in the earlier paragraphs. It was clear from the emails and attachments mentioned above that accused A5 to A18 are involved with UNLF as member of the organization. It was clear that A19 was the chairman of UNLF. So the whole thing regarding membership is based on the email. Subject to correction, I did not find anywhere that any of the other witnesses have been relied to hold that we are member. Although I'll be referring to these PW, PW 9, 17, and 39, I'll be referring to. But my crux of the argument will be, I'm hitting that there is no proof that I'm member. So actually, I'm not a member. So I'm hitting on that. But how emails have came to become admissible. If your lordship will remember, Information Technology Act came in 2000. And following that, Evidence Act was amended. Now, why I'm saying your lordship, because I don't know anything about the internet and others. But I'm sure your lordship is much acquainted and aware with it. So then Evidence Act was amended in 2000. Evidence Act. My lord, compilation volume 2, if my lords will take.
Yeah, I've got it.
48 it start. Yeah, sir. 48 it start. But
Yes,
my lord, 48, page 48.
yes,
Your lordship will come to section 3. Section 3 at 48, capital A. As I've said, these all we made in hurry, my lord, yesterday, Sunday and yesterday. Now, your lordship will go to next page, 48B. Evidence. Evidence means and includes, my lord, got it? At page 48B, the last portion. Evidence.
yes.
Evidence means and includes. Then your lordship go to next page, C, 48C. Subsection 2. All documents, including electronic record, produced for the inspection of the court. Such documents are called documentary evidence. And if your lordship will see, this amendment was brought in by next page 48D. It was substituted by Act 21 of 2000. So that is how these electronic records were also included in the Evidence Act. Now, my lord, will kindly go to 59, section 59 at page 49.
Yes.
All facts except, and this is the amendment, content of document, electronic record may be proved by oral evidence. Then the provision is there for electronic record that my lord will find at page 52 of the Evidence Act. The contents of electronic records may be proved in accordance with the provision of section 65B. This is with effect from 1710 to 2000. Now, my lord, a question came regarding for 59 and 65A, whether the electronic records can be proved verbally these emails or any electronic output. This question, my lord, first time it's subject to correction, came in Indira Gandhi assassination. No, don't talk. Anwar is 14. My lord, this is of Navjot Sandhu, my lord, that parliament attack. Navjot Sandhu, parliament attack. There, my lord, they say that it can be proved even orally. Two judges bench. Your lordship will see what the court said in Sandhu's case. My lord, Sandhu's case is 2005 11 SCC 600. 600. And because there says, because 59 is very clear. 59 says what can be given orally, so they accept electronic records. So it is a document. And 65 says the electronic records can be proved only by means of 65B.
So you're saying that that certification has not been made
No, in some cases.
in this case?
It is there in this case only, part certification is there, but it is not respect of electronic output, email. It's in respect of something you got downloaded. Your lordship is very quick. Ultimately, of course, I'll be leading to that. Your lordship, kindly come to page 66 of this compilation. This was discussed in PV Anwar versus PK Bashir. This 2005 11 SCC. Page 66, if your lordship will see.
Yeah.
Two judges bench of this court had an occasion to consider an issue on production of electronic record as evidence. While considering the printout of the computerized record of the call pertaining to cell phone, it was held in paragraph 150. According to section 63, secondary evidence means and includes among those things, this is of my lord Sandhu case, is quoted here in Sandhu's case, paragraph 150. According to section 63, secondary evidence means and includes among other things copies made from the original by mechanized process, which in themselves ensures accuracy of the copy, and copies compared with such copies. 65 enables secondary evidence of the contents of a document to be adduced if the original is of nature and not to be easily movable. It is not in dispute that information contained in call records is stored in a huge server which cannot easily be moved and produced in the court. That is what the High Court has observed in paragraph 276. Hence, the printout taken from the computer server by mechanized process and certified copy of by a responsible officials of the service provider company can be led in evidence through witnesses who can identify the signature of the certifying officer or otherwise speak of the facts based on his personal knowledge. Irrespective of compliance with the requirement of 65B, which is a provision dealing with the admissibility of the electronic records, there is no bar in adducing secondary evidence under other provision of the Evidence Act, namely 63 and 65. It may be that certificate containing details in subsection 4 of section 65B is not filed in the instant case, but that doesn't mean that the secondary evidence cannot be given, even if the law permits, and such evidence can be to be given in the circumstances mentioned above. Give me the book. No, give me the book. Pick it up. It may be that it was a case where the responsible officer had duly certified the document at the time of production. The signature in the certificate was also identified. This apart, in compliance to procedure prescribed under 65B of the Act, however, held that irrespective of compliance with the requirement of 65B, which is a special provision dealing with the admissibility of the electronic record, there is no bar in adducing the secondary evidence under section 63 and 65. So this was, my lord, the now this was overruled in this case only. I'll show from there. My difficulty is they have been, I have not marked. It was marked in the book and the book they have not drawn. And I'll just. I'm sorry, my lord, I'm taking your lordship's time.
We'll rise for 2 minutes. In the meantime, you look for it. Yes.
I placed that portion of Navjot Saturvedi, which says that even without 65B certificate, if there is evidence, it can be admitted. That was considered by 3 judges bench in PV Anwar versus PK Bashir, from where I have quoted portion I have shown. This starts with page 54 of my compilation. Compilation 2 given by us. And your lordship name is the.
That pertains to electronic records.
Yes.
Correct?
Yes.
But what about emails?
Emails also electronic record. It is produced by the computer. Page 54. The case is 2014, 10 SCC.
Yes, I think we know that part. Anwar, okay.
All electronic record.
PK Bashir's case there.
Yes, this is PK Bashir's case. You can
Yeah.
Then your lordship will see what happened to that Navjot Sandhu's case.
Yes. Page 66.
Page 67 at page 22, paragraph 22.
Yes.
The evidence relating to electronic record, as noted herein before, being a special provision, the general law on the secondary evidence under section 63, read with 65 of the Evidence Act, shall yield to the same. Then there is a maxim. Special law will always prevail over general law. It appears the court omitted to take note of section 59 and 65A, which I produced. Well, 59 says no oral evidence in case of electronic record. 59 says. 59 and 65A dealing with admissibility of electronic record. Section 63 and 65 have no application in case of secondary evidence by way of electronic record. The same is wholly governed by section 65A and 65B. To that extent, the statement of law on the admissibility of the secondary evidence pertaining to electronic record as stated by this court in Navjot Sidhu case does not lay down a correct legal rule. So on this point, that Sidhu's case was overruled. Then why I'm on it, my lord, I'll place Arjun Pandit's case also, 2020. 2020, volume 7, SCC 1. Your lordship will find at 113 of my compilation. In fact, 66. 66. 66.
Yes.
We have annexed only the relevant paragraph. It starts with at page 113, my lord.
Yes.
Relevant paragraph are 61. 61, my lord. There was a decision, my lord, of Madras High Court, which says that even Aliunde, it can be proved the electronic documents by way of secondary evidence. That was rejected. The lordship will see at page 114.
Yes.
We may reiterate, therefore, that the certificate required under section 65B4 is a condition precedent to the admissibility of the evidence by way of electronic record, as correctly held in Anwar and incorrectly held in Safi Muhammad. Oral evidence in place of such certificate cannot possibly suffice, as section 65B is mandatory requirement of law. Indeed, the hollow principle of Taylor versus Taylor, which has been followed in a number of judgments of this court, can also be applied. Section 64B of the Evidence Act clearly states that secondary evidence is admissible only if led in the manner stated and not otherwise. To hold otherwise would render section 65B4 obtuse. Next, in view of above, the decision of the Madras Court in K. Ramajayam, which states that evidence aliunde can be given through a person who was in charge of the computer device in place of requisite certificate under section 65B of the Evidence Act, is also incorrect statement of law and is accordingly overruled. So there is, now the law on the point is settled, that an electronic evidence can be proved only by way of either the primary evidence, the computer is brought, and before your lordship, the printouts are taken. That will be primary evidence, no certificate would be required. But if they take the printout, and that printout is brought before the court, requirement of section 65B4 is signed for now, for its exception. Otherwise, it will not be admitted in evidence. I'll place 65B when I ask, otherwise there will be repetition. I just clarified the law on the point. My lord, as I have stated earlier, submitted earlier, that emails were allegedly retrieved on the basis of the disclosure statement made under section, made by accused 18 and 19. I'll place first the disclosure statement that was made by accused 18. Your lordship may have exhibit paper book 2, part 2, below 2. Okay.
Part 2, volume.
Part 2, volume 2. Volume 2.
Yes.
This is exhibit,
So your case is basically on the email and disclosure statement. Email and the disclosure,
non-disclosure statement. My case is, there is no compliance with 65B4.
that's all. Then why are we going to the disclosure statement?
Sorry,
Why are we going to part
because
two?
on the basis of these emails were retrieved.
Yeah,
So I'll have to show what a statement was made, how the emails were discovered. Because there are two certificates are there. And the other is, what are the emails which have been sent to Chandigarh forensic? And the emails were taken there without original, that they have taken out. Those emails which could not be retrieved here or taken out here were stored, were put in a transfer in a hard drive, and those hard drives were sealed and marked exhibit H1 and H2 as per the CSSL statement. And then they took out the printout, and there is no certificate, and they could not have certified also because it was not, the original computer was not with them. So because of that, I have to take your lordships through disclosure statement, recovery memo. Page 415
disclosure statement of,
accused number 18. Your lordships through
yes,
all this. Page 415, my lord will see. Exhibit 1111. Today on 18/11/2010 at 16:30 hours at NIA office Splendor Forum, so and so district, accused Moirangatam Joy, he is 18 of so and so, during examination has disclosed voluntarily in the presence of independent witnesses, so and so, so and so, then whatever he has disclosed is given. He says about, I'll read it only. I'm a member of UNLF since 1982, presently the organizational secretary of United Nations Liberation Front. Under the chairmanship of R.K. Megan, I used to send and receive details UNLF activity through my email ID, namely Green Plate and Green Field. These are the two email IDs that he has disclosed. With the help of my laptop seized from my possession to the other members of UNLF, but not limited to. Now, these are the names, my lord. R.K. Megan, Dilip, Abal. I'm not there in any. We are not there in anybody whom I'm protecting. Now, if my lord will kindly, just one thing I want to point out, otherwise I will have to come back again. This he used to send, he says, email, two email ID, Green Plate and Green Field. With the help of my laptop, your lordship will kindly mark it somewhere, laptop. And laptop was seized from him, but the emails were not taken from that.
emails can be taken from anywhere.
That's
from
right.
No,
But
from the email address.
IP address, your lordship will know better than me in this.
No, I'm
IP
as blind as.
I do, he does everything. I don't know how to operate. But what I am told that original laptop from where or computer from where emails are sent, it has IP address. That IP address your lordship will not find in other computer, isn't it? It will have a difference. So, but anyway, that is not, we are not disputing those things, we are not going into it. And I can recover the aforesaid communication made by 3 emails. There are 3 made by their emails. These it should be typing mistake. These emails, green plate and green field. Yes. So this is the disclosure statement. Now, your lordship will, on the basis of this, the recovery was made. Now I have annexed my only disclosure statement I could not annex. Now the recovery memo. There are 2 recovery memo in respect of accused 18. 2 recovery memo in respect of accused 18. One is exhibit 112.
Page,
Your lordship, convenience, I have annexed here in the compilation 1. I can refer from there also, my lord, if it is inconvenient. Because
yes, anyway, yes, compilation 1, yes.
page 72. No, I can refer, my lord, I'll refer from there. I have both.
You refer from
Yes,
here,
yes.
otherwise it becomes problem with turning too
Yes.
many
Yes.
volumes.
Now, your lordship will see, go to page 419 in the same paper book, exhibit paper book 2. In continuity to the disclosure statement made on 18/11/2010 of the accused. Sorry, 417 memo. There are 2, I said, recovery memo. The first one, 112. In continuity with the disclosure statement statement dated 18/11/2010 of the accused in custody. Is accused number 2, my lord. That is 18/11, 18 hours in presence of witness, namely so and so, so and so. The Sri Siva Prasad Mohanty, Network Administration of NIA, accused so and so was given access to NIA office computer and internet place at the NIA office, Splendor Forum, so and so. In order to open his email ID on getting the access to NIA office computer, he opened his email ID, that is green plate, and entered his password. On being inquired, he mentioned that his password was so and so. Thereafter, the details of the emails appeared on the computer screen. The printout of the screen appearing on the computer was taken out. Your lordship will kindly mark it. The printout was taken from green plate. Thereafter, the accused was asked to open the email available in the email inbox, email sent to other as well as email available in the draft.
Where are you reading? Page 419.
417, you know,
Oh,
that is the first disclosure. I'm sorry. Recovery memo, madam.
the other one is also recovery.
Yes, I said there are 2 recoveries pursuant to the disclosure made by the accused number 8. There were 2. So sorry, I'm sorry. In continuity to the disclosure statement dated 18/11/2010 of the accused in custody, I'll read accused number 8. my lord, 18. In presence of witnesses, namely so and so, accused so and so was given access to NIA office computer with internet placed at NIA office in order to open his email ID. On getting the access to the NIA office computer, he opened his email ID, that is green plate Gmail, and entered his password. On being inquired, he mentioned his password as so and so. Thereafter, the details of the mail appeared on the computer screen. The printout of the screen appearing on the computer was taken out. So the printout was taken out here.
From whose computer?
There's computer which is there in the NIA. There is no detail of the computer. NIA office computer, it's mentioned here. Ready. So printout of the screen appearing on the computer panel was taken. Thereafter, the accused was asked to open email available in the e-box, emails sent to others, as well as emails available in the draft. The accused voluntarily provided the password so and so, and what is that? To open some password perfect file. The printout of each of the emails sent, received, available in the draft, taken out. These printouts were numbered from 1 to 2781. 2,781 emails were taken out and were signed by the aforesaid independent witnesses. Since the accused complained of uneasiness in the proceeding of transfer of contents of email to a sterile disk was postponed for tomorrow, because they wanted to put it in a sterile disk so that it can be sent to the FSL. The recovery memo was read over to all present, and the same was signed by all present, including accused in custody and independent witnesses. The proceeding of this memo was concluded at 2022. The next recovery is on the next date. In continuity to the disclosure statement made on 18/11/2010 of the accused.
Okay, so it was recovered from there.
Yes.
Now.
Now here,
No,
yes.
so.
Yes. Now your lordship will see. Both were recovered. Second one, second email coming. My lord, one thing I just want to point out here. There were two email IDs allegedly disclosed by.
Yes, he's got two of them.
Now, so far as the ID in green plate is concerned, the printout was taken. This is clear, is what I. Lecture 112. Exhibit 112 at page 417. 2,781 from one email was taken. Page 417. The email from other was not taken out. That's what I want to show. At page 420, it is not.
So one is enough, I think.
Nothing is enough unless everything is proved. I'll say that with all respect. Kindly come to 420.
4-2?
420. I'm continuing with that. 419 I started.
Yes, yes.
Thereafter, the accused in custody voluntarily stated that he is having another email ID, green_field. However, the contents of the email used by the accused in custody could not be retrieved as he was unable to provide password. So only one email was opened. These will be important when I take your lordships to the certificates under 65B. That's why, my lord, I'm placing it. Now, these emails which were retrieved,
Yes,
not all, but some of them were exhibited as Exhibit 115 series. So 115 series relates to the emails which were allegedly retrieved on the basis of disclosure statement that to have been made by accused number 80. And this was printed in NI office. By PW 53. He is the person who says it was printed. He says in his statement only, PW 53 Satish Chandra. And he is the person who has given the certificate.
PW 53 gave the certificate.
He, PW 53, his certificates are relatable to the emails recovered at the instance of accused number 18. Now, I'll take your lordships through the certificate. One certificate which he has given. 421 of the same volume, page. This is exhibit 114, page 421. Exhibit paper book 2, part 2.
Put on the AC. Very hot.
It's very hot, I'm sweating. Four to one, your lordship has taken.
Yeah.
This is exhibit 114. I, Satish Chandra. Deputy SP, ITNI. I'm in charge of Information Technology Wing of NIA headquarters, Splendor Forum, New Delhi. I hereby certify that the computer installed at the NIA office at New Delhi, from where data retrieved from email on disclosure of the accused Moirangtham, accused number 18, in police custody is under my technical control and supervision. I further certify that the process of downloading of the above email was uninterrupted. No, it doesn't certify that the printout was taken.
Then the
Which is the-
printout was?
Taken, which is the requirement of 65B4. I'll place that. He just said the process of downloading was uninterrupted. Downloading and printing are two different things. Pandit. Arjun Pandit. Yeah, yeah.
Anything else?
Hello.
Anything else?
Yes. Yes.
65B, okay, now according to you, it was
No,
downloaded,
no, I'll-
not printed.
Yes, I'll have to show, my lord. I'll also have to, I think, remove that your lordship says whether this is email.
Whether
I'll
it
have-
is,
This is email,
Ah.
so I will show from the decision of the Supreme Court that emails are also computer record, electronic record. But this case is going to take time, I'm very sorry. my lord.
no, no, it's okay.
Ah,
That's why,
And,
yeah,
because-
it will take time, but it doesn't matter, but
No, if
let's
I'm-
try to hurry it up a bit.
no, I'm not, No, because there are two reasons.
Uh-huh.
One is, they all know I'm not keeping very well. So I will continue, but still, because I've taken the responsibility, I have to discharge it. So I bail also, I was there. So that is one thing where I will need some, my lord, accommodation from the lordship.
There is no.
No, I'll take. No, because so, my lord, at the cost of repetition, I'll submit what is the contents of the email. So, contents of the,
So now
Certificate.
we go to the email or to the certificate.
no, certificate, I'll take your lordships to the email.
Is this,
individually.
so is this the only certificate or is there any
No,
other
no,
certificate?
no, there's no certificate, no other certificate. There. In this, my lord, insofar as 18 is concerned,
A6, 18, A6, 18.
because on his disclosure,
Ah.
there is only one certificate. Because it was by 50, PW 53. The other were discovered or recovered at the instance of A19.
I-19.
That was by another person, that is Shiv Kumar Mohanty, is PW 74. So there are two certificates. One certificate I have placed. The other certificate also I will place, but I will first place accused 19.
So page this certificate that we have just read
Yes,
is by PW.
53. He is Satish Chandra,
Okay.
not P. THEES, South Indians, they write this. So
PW 53.
PW 53, I'll place PW.
So now so the other disclosure
Yes,
made by accused 19.
Yes.
Due to which there was some recovery of some other document
yes,
pertains to
email.
a different email
yes,
and of a different person.
Yes.
Basically of 19.
19.
And that has been authenticated or certified by PW 74. Okay, now,
So
Uh,
I'll first analyze what are there in the certificate.
no, we would, just a minute,
Yes,
just
yes.
let me write. So this, certification by PW 74, where is that?
That is,
Huh?
Exhibit 160,
Page
page 921.
95,
921,
921.
part 2, volume 4.
and both these certificates under 65.
Yes,
Both these certificates are verbatim reproduction of each other.
you are waiting?
Reproduction of each other.
Okay.
And therefore, what are the contents which I have just placed? Summarily, I will say, divide it into three parts. Number one says, computer is installed in NIA office, New Delhi. And the computer so installed is under his technical control. Second is, the certificate disclosures data retrieved are on the basis of disclosure statement made by 18. And third one is, process of downloading of emails was uninterrupted. These are the three things, the certificate. In the other also same thing, I'll place that. Now I come to email retrieved as an instance of A19. That disclosure memo are not good. I will not place it.
Disclosure is at what page?
Disclosure statement is dated 11/12/2010.
Yes. Page,
Page 916, capital A, paper book 4. Part 2, volume 2. Exhibit, part 2.
part two, volume four.
Lakshya, permit me, he'll read out.
Exhibit 160.
Page
Page 916, capital A.
916, volume, just a minute. Part two, volume four. Yes,
Page 916, capital A.
yes,
Today, that is 11/12/2010 at 11:30 hours at NI office, Splendor Forum, so the accused RK Megan, he is accused number 91, who is under police remand, during his examination has disclosed voluntarily in presence of independent witnesses, namely so and so, that he is a member, I am a member of UNLF since 1967 and presently the chairman of United Liberation Front UNLF. I used to send, receive details of UNLF activities through my email IDs, namely 123. He has disclosed 3 email IDs, madam. One is salaitaret@yahoo.com. Second is enterprisedk@gmail.com. And the third is pathfinder@hushmail.com. With the other members of the UNLF, including but not limited to, with whom he has communicated, he has given a list. Thereafter, he says,
yes,
he also voluntarily stated in presence of the following independent witnesses that he can get recovered the aforesaid communication made by his email, that is Salaitaret, Enterprise DK, and Pathfinder, if given access to any computer with internet connection at the NI office. This memo was read over to all present and leaders. And thereafter, the recovery was made. The recovery exhibit 167, the next page, madam, page 918.
yes,
In compliance to the disclosure statement made on 11/12/2010 of the accused in custody, so and so, accused 19. And so and so, he was given access to the NIA office computer.
My lord, here, just he says about 3 email IDs, but the emails could be taken only from one. Only that I will show. Page. Yeah, we are 19. No, she will come to 97, 919, next to 919,
yes,
919.
yes,
Uh, First, the second line from the top, my lord.
yes,
The print out of each of email Enterprise DK sent and received and available in draft, chunk and others were taken. So then, so only from this, the other two, they could not take. And it's mentioned here. these printouts were numbered from serial number 1 to nothing is there. It's blank. And were signed by the aforesaid independent witness. Printouts of the emails saliterate was not taken. As the witnesses were getting late, however, requests for printout of these email will be made to forensic expert. So this will be taken out by the forensic expert. Email from saliterate. This was not taken out in NIA office. Then your lordship will have seen two. One email was taken, that is DK Enterprise. Saliterate email were not taken out in the NIA office. And then your lordship will see the third one, Pathfinder. My lord, at page 918. Fourth line from the bottom. The third email ID, Pathfinder so-and-so, was tried by the accused to open by typing password. Since the email was not open for more than 21 days, the email could not be accessed. So only email from one ID, that is Enterprise DK, was taken. Printout was taken. Now I'll check your lordships to the next page. The certificate I'll show me. The lordship will find at 922.1. 921.
Yes.
I, Siva Prasad Mohanty, Network Administration IT Wing of NIA Standard Forum, New Delhi, do hereby certify that the computer installed at the NIA office, New Delhi, from where the data retrieved from email on disclosure of the accused R.K. Meghran in police custody is under my technical control and supervision. I further certify that the process of downloading of these emails were uninterrupted. So similar, this is verbatim, that's why I said verbatim of the earlier certificates. The lordship may compare. The earlier certificate is at page 4, page which one? That of course is in exhibit paper book 2, 421. It's verbally verbatim. So none of them certified that printout of the emails were taken in their presence from the computer. None of them have certified. Now I'll take your lordship. Now I'll take your lordship through 65B. Earlier I have taken up to 65A. I'll take your lordship through 65B, which provides what should be the at page 52 of compilation 2. Notwithstanding anything contained, my lord, your lordship will kindly mark it. It starts with non-abstentive clause. That has been referred in my lord the Bashir case as well as Arjun Pandit case. Notwithstanding any of these rules out oral evidence, which are there in the Evidence Act in 59, Section 59. Notwithstanding anything contained in this act or any information contained in any electronic record, which is printed on a paper, stored, recorded, or copied in optical or magnetic media procured by a computer, hereinafter referred to as computer output, shall be deemed to be also a document if conditions mentioned in these sections are satisfied in relation to information and computer in question, and shall be admissible in any proceeding without further proof of production of original as evidence or any content of original or any fact stated therein of which direct evidence would be admissible. So this is a document. This computer output will also be document, provided it complies with 65. Otherwise, it will not be a electronic document. Condition referred to in subsection 1 in respect of computer output shall be following, namely, computer output containing the information was produced by the computer during the period over which the computer was used regularly to store or process information for the purpose of any activity regularly carried on over that period by person having lawful control over the use of the computer. There is also a requirement. During the said period, the information of the kind contained in the electronic record or of the kind from which the information so contained is derived was regularly fed into the computer in ordinary course of the said activity. Throughout the material part of the said period, the computer was operating properly, or if not, then in respect of any period in which it was not operating or was out of operation during that part of the period was not such as to affect the electronic record or accuracy of its content. The information contained in electronic record reproduced is derived from such information fed into computer in ordinary course of the said activity. Where over any period function is stored, a function of storing, processing information for purpose of any activity regularly carried over that period as mentioned in subsection 1, clause A of subsection 2 was regularly performed, whether a combination of computer operating over that period or by a different computer operating in succession over that period, by a different combination of computer operating in success over the period, or in any other manner involving the successive operation over that period in whatever order of one or more computer and one more combination of the computer. All computers used for that purpose during that period shall be treated for the purpose of this section constituting a single computer, and references in sections to a computer shall be construed accordingly. In any proceeding, this is the certificate. Now we come to the certificate 4. In any proceeding where it is desired to give evidence, give statement in evidence by virtue of this section, a certificate doing any of the following things, that is to say, identifying electronic record containing the statement and describing the manner in which it was produced. It is not there. The electronic record itself is not identified. They say data were retrieved, and the process of retrieving data was uninterrupted. That's what is there in certificate. B, giving such particular of any device involved in the production of that electronic record as may be appropriate for the purpose of showing that electronic record was produced by a computer. There is no particular of computer. They say computers stored in NIA office. We don't know how many computers are there in the NIA office, from which computer they have, because they have to certify that this computer was properly functioning as per requirement of subsection 2. then dealing with any other matter to which condition mentioned under subsection 2 relates, and purporting to be signed by person occupying a responsible position in relation to operation of the relevant device or the management of the relevant activities, whichever is appropriate, shall be evidence in any manner stated in the certificate, and for the purpose and for the purposes of this section, it shall be sufficient for the matter to be stated to the best of my knowledge, belief of the person stating. And 5 will not be relevant, shall not take your action. So these are the certificates. And my lord, in Bashir case, it has been provided what should be the content of the certificate in Bashir case. Bashir case. It's in the compilation 54. Well, otherwise, if your lordship is not listening, I can give list of books and those books can be,
No, your books are here.
all right.
Nothing.
Then
no-
54.
Ah.
Page 54 of my compilation 2.
Because I think the facts will be different for each case. Correct? Or
Uh,
is it all on email?
in so far as this point is concerned, if your lordship agrees with me that the certificate under 65B is not as per the requirement of law, then Bashir and Arjun Pandit will come that the emails cannot be proved any other way, alternative way, other way. So if on this I'm able to convince your lordship, then it will not be necessary.
No, so basically, on the basis of emails, you were held to be a member of the unlawful assembly. I
Yes.
mean unlawful
Terrorist
organization, terrorist organization.
Yes.
Along with how many other persons? Or all were based on, all were based on
all-
this email,
Or email.
only email.
Paragraph 52 I have placed with your lordship.
So all on email. So everything, so basically, yeah, that
Everything
the issue is basically the emails.
Yes. Email, and then certain things like my activity supporting, I have invested money of UNLF, those I have said PW 7, 9, 19 and 39.
So the basic thing is email.
Email.
Hmm.
That's why I referred paragraph 52. That. So that's why this is the only point which is going to take time, I said in the beginning. So here, there, I'm making my effort so that I'm able to convince your lordship on this, about the certificate.
I don't know about the, I'm only worried about how long it will take to complete your side of the
My
argument.
lord, I'll take some
We'll
time.
carry on after lunch also. We'll carry on.
Today it will not be possible. I'm already having pain. This is my problem, and that's why I said, my lord, your lordship may have to do some accommodation. The other, they can proceed, my lord, read the evidence if they want, but it will not be required. On this, it will be, and
Okay, so the entire thing is based on email. And then there are two other points you said with regard to which of the
My lord,
appellants.
the other is evidence of PW 9,
Evidence of PW 8,
PW 9,
evidence of PW 8 and 9.
PW 9, my lord.
Not 8,
No.
9.
9,
PW 9,
17
9, 17
and 39.
and 39.
These are the things, there's nothing else.
Okay. No, so one point according to you is the emails.
Yes.
And is there any other factor involved in decide?
I can just say. Now suppose, for a moment, let me assume that your lordship says, okay, I'll go into other point also.
Yes, yes. We want to do that.
Yes, then I'll take you, your lordship to the emails.
Ah.
And just to show that these emails also do not constitute any offense, even if it is accepted. Now, for example, I'll just give one example. My lord, suppose A writes to B. Emails are like later only. So A writes to B that C has killed D. Is this proved? I'm asking myself. Because on this, I got the bail of all the accused. When Justice, Chief Justice was at the thing. My lord, emails are nothing but an information given by one accused to other accused. But the facts of the emails have to be proved. Like,
No, that is one aspect of the matter.
yeah,
Hmm.
that's the second aspect of the matter.
Okay.
That even if you take everything without adding or subtracting, no case is made out.
No, that is on the aspect of whether any crime has been committed by him, any
Yes.
act has been committed by him.
Yes.
So that is on that point.
Yes,
The first point is whether he is a member of that
that
organization.
only,
Okay, according to you, the first point is whether he is a member and whether any terrorist act has been committed.
Yes.
Now, besides that, is there any other ground on the basis of which the learned trial court has convicted
No.
your clients?
No.
No,
in
it's
fact, the
only on
judgment,
email.
there's no clarity at all, which I'll place with your lordship. I'll place the judgment.
Okay, I'm on the facts. The
Yes,
judgments can come
Yes,
later
no,
on.
no, that's why I'm saying, because the trial court is not, there has some to be clarity in the judgment when it is written, but with all respect, there is no clarity. And the issues which I have said are only two. Whether I'm a member, number one, or by referring to the emails. Now, suppose emails, your lordship says, okay, emails are admissible, we'll admit it. Then whether the contents of the email involves us. Because all of you blue, they will not say there is an email between A and B. So therefore, C has killed D. It is proved. It's not possible. That statement has to be proved. If your lordship remembers Vidya Charan Shukla and L.K. Advani's case, Jan Hawala diary it is known as. There were loot sheets which were found in one Jan's house.
SKJ.
So there the L.K. Advani's name is there. I just think V.C. Shukla's name is there. The Supreme Court says, first of all, these are not admissible and in evidence because it is hit by 34 of the Evidence Act. And Supreme Court further said that merely entry, there is an entry in that in a diary or in a piece of paper will not be sufficient to hold the person responsible. Rather, it has to be proved. It's a fact which must be proved. So these are the grounds that I'm urging in respect of accused number 6, accused number 8, accused number 11, accused number 15, and accused number 23, 24. These are the grounds, madam.
We'll hear the rest after lunch.
Then by the lordship's permission. And
We'll
tomorrow,
hear you after lunch.
The side is standing on one extra version. So-
Correct. No, the thing is that you see, if we carry on like this, we'll never end.
No, because same people super. Appellant number one, case number one is mentioned. Because in one of the emails I found to be the wife of
Oh,
one Carter. That's what that's.
okay.
This is what that's. I'm simply a wife.
No, so you tell me your facts of the case.
Because
what
sir has said, because if you can open up the entire case, only administrative evidence.
No, you see, all those issues we will decide. We cannot say we are deciding this point first, now we want to hear the next point. The cases cannot be decided like that.
I can argue my case.
Yes.
It will be.
We will not complete it.
Because.
No,
but
no.
I would like to argue. So for the.
You want to argue only on facts. You want to argue on facts, basically.
Because actually, I plays a fact,
Correct.
but no one shall be copied.
He will do that. He will do it.
Because again, if I.
He doesn't want, you see, he is not feeling well. He says that he doesn't want to continue after lunch. But if we keep on adjourning the matter on that point, then it will be a never-ending exercise. So we will wait for him for another day, tomorrow maybe. In the meantime, you carry on. We will hear you. Then he will carry on again tomorrow.
tomorrow I'll carry on the whole day.
Ah,
I'll
and
come
then
prepared.
we will ask them also to do whatever. So that, there's continuity. Otherwise, if we keep on doing this, we will never end. And it has to, the reason we have adjourned all the cases today is you all said that you all will take the whole day. So the thing is that we are ready to hear you and dispose of the matter. But we are not ready to adjourn the matter for you. Because you should have told us in the very beginning that, sorry, we do not want to do it, we'll have to do it 1 week, 2 weeks later, that we cannot do. We'll hear you day to day and we'll dispose of the matter.
Tomorrow I'll complete.
Yes.
Tomorrow I'll complete.
So at 2 o'clock, we'll hear you. And if you want to add something, we'll give you time tomorrow also. There's not an issue. But we want continuity. And then if you finish today, we'll ask them to give their reply. No. Otherwise, no point. Otherwise, otherwise we would have wasted the whole day. If you all say that you're not ready to complete hearing in the near future, then we'll adjourn the matter. But if you all are wanting to dispose of the matter, we'll hear you and we'll dispose it off.
I could have continued my.
I know. No, we understand. It's not that. We're just saying that since you are not feeling well, we are ready to hear the others in the meantime. That's all. Maybe we list it day after tomorrow.
After tomorrow, keep on morning. Tomorrow is
The problem is that
11.
that is the problem with these cases. Unless we do it continuously, we forget. And
Then in that case, my lord, 11th may not be, I will be out of station.
May I say something? We get a smaller amount of time to finish the case at a stroke. If lordship hears the whole matter at a stroke, then it is easier for both the sides. My friend in the other side, for hours and for your lordship also, to make a note and to finish it up. So my lord, if immediately after Bihu, if lordship pleases me, then can it be listed in the first half or the other first item? I will be finishing it within 2 hours. It was not burden to your lordship and the other cases. For the interest of this case, because we are carrying it for a long.
I know. We can. How long will you take?
Maximum 1.5 hours, maximum.
And he will take.
They have completed their part.
Maybe acquiring your document, reply.
In reply, he will say something. No issue.
That is again the problem. No, again you say 1.5 hours. He may want to make a reply.
No, my lord, that in that case, my lord, if we start in the morning, then before lunch it will be finished.
Supposing we do your case at 2 now, can we finish it by 4:15? I've got a meeting at 4:30.
Yes.
Yes, okay.
I will try to finish it by 1 hour, my lord. Because lordships are already aware about the facts, I have to place certain law.
That's it.
Nothing.
Nothing more.
I don't know, Mr. D.K. Das and Mr. Chaudhary, what to do?
Suppose it's that it was not prepared.
Mr. Singh is not very inclined to argue the matter, it appears. Yes, he's not very inclined to argue. Only thing is that, you see,
Lordship will take it to compromise.
yes. Mr. Singh, so you're not very prepared today or what?
I have prepared only for one appellant that I can place. That or I can continue to. I prepared for one appellant, I prepared it, I can place.
You're appearing for how many appellants?
There are 13. My learned senior is appealing for this.
Yes, around 5 or 6, yes.
Because no point is short, is my learned senior.
So, yes,
Only have to put the facts in the.
the facts. So for each one, the facts are different.
Yeah, it should be different.
And you're prepared for only one.
Yeah.
Okay, we'll take it up. We'll take up that matter tomorrow then. What do you say, Mr. Das? What to
I'll go
do?
with your lordship, madam.
No, because they want to finish their case also, the Neeraj Sharma's case. It has been hanging fire for some time.
Quite good, but I understand that, madam. No problem.
The second half you will not finish. Again, 100% guarantee. Huh?
Tomorrow, part one.
Oh, there'll be a part one this one.
Tomorrow there will be person.
We can try, we can try. Okay. Okay, that's, in this item 1 to 13. Item 1 to 13, you just say. On the prayer of, Mr.
G
Singh,
Singh, Gunadhar Singh,
G Singh,
Gunadhar Singh.
list the matter tomorrow. Okay? No point hearing halfway. Then, one thing, just hold the thing, my plastic packet was there. There's a plastic folder.
16 also, Lordship, after respect of item on 15.
Item 16. Okay, item 16, list the matter after the vacation. Now let us put away all these papers. So we'll hear you then.
1 to 13, Manohar, your lordship has heard, 1 to 13, your lordship has heard, DK Mishra.
Ah,
DK Mishra, that may come, DK Mishra.
tomorrow we have listed it. You do this, clip it. Yeah, no, you put it there. Yeah.
এইটো এখন continuously আমি কৰি যাব লাগিব।
Item 16, we have adjourned it after Bihu, na? After this.
এখন মিলাই মিলাই কৰি যাব
What to do?
লাগিব। Page number বিলাক refer কৰা।
Paucity of time.
ইয়াৰে page number বিলাক ইয়াতে refer কৰাই দিয়া আছে। এইটো ধৰক এইটো এতিয়া।
Yeah.
এইটো আমি court ত দিছিলো। দিয়া। Okay. It is page 170. So page 169. Into 169 এটা ওলালে। এতে 169 paragraph 23. Because of physical problem. Mainly আৰম্ভ হ'ব এইখিনি। This তিনটা issue, এই তিনটা issue পৰা আৰম্ভ কৰি judgment কেইটা কৰি দিয়া হ'লে।
What are we at? This thing?
Yes. This includes the written argument and the judgments, copies of judgment that we have relied on. The Lordship will kindly take the writ appeal 5 along with the compilation.
Yeah, my.
Any point, if the point of page 4.
Yes.
Yes. So by now, lordships have taken note of the entire facts.
I hope so. I don't, I hope so. We've been having a long vacation.
Just for refreshing the memory. The respondent number 5, the writ appellant number, appellant number 5. He was appointed first as the protocol officer.
Yes.
Protocol officer with a rider that his seniority will be considered in the, for next promotion in his original cadre. That is SJA, Senior Judicial Assistant. Protocol officer is a different post higher than the Senior Judicial Assistant. It is higher post, but not in the line of promotion. It is not the line of promotion for SJA.
Okay, for SJ, there is SJ.
Yes.
For senior, he's a senior,
Senior Judicial Assistant.
senior judicial assistant. What is their promotional post?
Their promotional avenue will be open for the post of administrative officer. AOJ. Assistant Administrative Officer.
AOJ.
AO.
Lordship can refer to page
Huh?
17. Page 79 will given a.
79, Lordship may kindly turn to of the readable five. Their lordship will find they have given a list. I mean, the chart, flow chart, which shows chronologically how the post will go up.
So he is a SJ.
He was SJ, senior
SJ.
judicial assistant,
So SJ's promotional post is court master
court master,
and court officer.
court officer, and
AOJ.
AOJ,
Administrative.
And AOJ.
yeah,
Ah.
administrative officer, judicial. So here the lordship will see the extreme right, they have shown the protocol officer.
Huh.
This protocol officer is not in the line of promotion. This is placed in a different side. Not,
No direct.
not direct promotion from SJ. It was that way a cadre independent itself, which cannot be occupied directly by way of promotion from the post of senior judicial assistant.
A separate cadre by itself.
Separate cadre by itself.
But this protocol officer comes within which what is the
AA,
2AA.
2A?
2A.
Protocol officer comes under 2A. Just give me the Bhatti High Court rules.
Yes.
Not the rules. Which is the rules?
It is in the schedule.
Huh?
It is in the schedule.
Schedule of the Guwahati High Court rules.
Okay.
Page 240.
Page 665. It is in class 2C.
Class 2C, yes. Please stand corrected.
Page 665. Milord will take up. This book, my lord. This
Yes,
book.
yes,
Page 665 towards the end.
yes.
Class 2C includes AOJ, stamp reporter, court officer, protocol officer, assistant librarian, senior system, but not court master, court officer.
Class 2
C,
C.
right hand side.
Court officer is included.
Protocol officer.
Protocol officer ex cadre. So it's
No,
a
no,
ex
it's
cadre
not-
post.
Not ex-cadre, my lord. Earlier it was, but later on it was encadred with effect from 1990. With effect from my lord. I have annexed that notification also.
Yes, so class 2C.
Yeah.
Yes.
Class 2C is encadred. Earlier it was ex-cadre. It was, later on it was encadred. I will show the notification.
Now, therefore,
এখানটা করছে ভালো করে, সেখানে না করছি। এখন
এখানে আছে।
ও,
তাই না? Now, my lord. So, he was appointed as a protocol officer. And the appointment of the protocol officer was made with a condition that lordship will find at page
140. Start from 140. 143.
lordship may kindly come to page 143.
Yes.
Advert options.
Now, here it says, this is notice inviting options. Options are hereby invited from the intending senior judicial assistant of this registry for filling up one vacant post of protocol officer. Lordship will see one vacant post of protocol officer in the principalship, Guwahati, so and so. Preference will be given to those senior judicial assistants who have continued 5 years of service. Now, second para, the selected candidate for the post of protocol officer will maintain his her seniority in the original cadre, and his her further promotion will be considered on that basis. Further promotion
On that basis.
on that basis.
On that basis means which basis?
That seniority basis
Seniority in the SJ.
in the SJ. in her seniority in the
Then-
original cadre. In the
That is
original cadre.
another protocol of the promotion from the appointment of the secretary to the post of secretary to the chief justice is not a promotional post. It's a direct recruitment.
So also the protocol officer.
So also the protocol officer. Therefore, promotion, since the promotion, channel of promotion from protocol officer and secretary is different. There is no direct promotional channel from protocol officer. Therefore, this rider was given, because the career of that person cannot come to a stagnancy. That is why this rider was given. Rightly or wrongly, it was given. Because if this man wants to go back from the post of protocol officer, then he will lose his seniority in the original cadre. For some reason, if his service is not satisfactory, then he has to send back to his original cadre. Because these postings, secretary and protocol officer are subjective posts. They will continue in their post on the satisfaction of the appointing authority. That is why these options were kept open, so that he will not lose his seniority in the original cadre. But till the moment he is there as a protocol officer, his appointment is a substantive appointment. His service is a substantive service.
Protocol officer was in cadet when?
Because,
It was 19 something,
cadet.
1991.
The pay scale is higher, protocol officer.
Higher pay scale. It's a gazetted post. SA is not a gazetted post, ministerial post only. We have to, my lord, accept these things, that till the moment he is holding the post of protocol officer, he is in substantive capacity. Therefore, considering he is for the post of secretary, either on officiating or for the permanent appointment, is valid because he holds that post in group 2C. My respectful submission, my lord, determining factor whether his appointment of protocol officer was a substantive one or not. These two lines is not the determining factor. Determining factors has been set out by the Supreme Court. We have cited those. We'll show to your lordship once more today. Whether that appointment was a substantive or a ad hoc appointment or an officiating appointment or a temporary appointment, determining factors are not these two lines. Determining factors are different.
In which case?
Why not it Balasore, all the cases we have cited, will cite. Why not come to page 6 of that booklet, my lord.
Yes.
Page 6, my lord, Romans 8. What is substantive appointment and what
Page
is?
6 is this, page 6 is this.
No, this first page 6, my lord, numerical page. Of this written argument, my lord.
Yes. Page 6 is this, page 6 is.
No, no,
Supreme Court.
lordship has gone to the judgments, not
Okay,
to the
okay,
judgment
okay, okay.
of the written argument. Roman 7, 8, sorry, Roman 8. These are the cases, it's clearly spelled out how to determine or constitute the what is a substantive appointment. And my lord, going one step ahead, my lord, Honorable Supreme Court further said, and our division bench of our High Court says, that only because that condition is given in the appointment letter or in the advertisement, that cannot nullify the rules, or that cannot.
But what are the rules?
That is what the crux of the issue that Lordship, I'm so happy, my lord, that Lordship asked this question. Let them show what rules has been violated. This is the crux of the whole thing. There is no rules. If there is no rules, then where is the violations? I'm grateful, I'm bowed down to your lordship. This is the crux. This is the heart of the whole thing. There is no rules at all prescribed. What has been followed since
If there are no rules, can he be promoted in the absence of any rules?
but it was going like this, the committee resolutions are being followed by the Chief Justice in previous appointment.
Lord, even if
And-
we, just, even if we take it that there are certain guidelines, executive instructions. The petitioner will have to satisfy which guideline is to violate. If there is a set of rules, the which rule has been infringed. How their right has been infringed. The fact remains here that the post of protocol officer was filled up by giving option. That is the procedure followed. By giving option to all intending candidates to opt for. And from amongst them, the authority will choose one. All who have given option, they were subjected to scrutiny. And after scrutiny of their records, the authority took the call that my client should be appointed as the protocol officer. It contained that particular two lines that his seniority will be maintained in the original. In case of promotion in future, at the event such a situation arises, then
So that condition.
Yes.
Basically stated that his promotion would be on the basis of his seniority in the SJ. Correct?
well, not as such.
Naturally, that,
Because this is not a
that is
promotion.
that is all can be inferred from that anyway.
No, well, if I may just clarify, that promotion, in case of in future promotion in that line, promotional avenue, channel will be open for him. And if he at all occasion arises, then his seniority will be counted as he was holding on the date he was appointed as the protocol officer. That seniority position will be counted, so far he is concerned. If there is someone else above him, but it may so happen that in the SJ there are senior persons to him in service, but who didn't apply, didn't opt for the post of protocol officer. Or even if applied, were not chosen, not selected. Then in that case, that seniority will maintain in his original post as they. And when I am taken there is a higher post, but if for some reason I am not found to be satisfactory and I am to be reverted back, probably that option was kept by this authority open. At the event, services are not found to be satisfactory, they be reverted back, and then that case his promotional avenue will be open, and in that case his seniority there in that cadre will be continued. So therefore, well, that by itself will not determine the nature of the appointment to the post of protocol officer. The nature of appointment to the post of protocol officer would be judged on the procedure followed and the nature of the post which was filled up, whether it was permanent, whether it was temporary purely, and the appointment was whether sought to be made temporarily or it was sought to be made regularly on regular basis. Again, lordships are aware that even in temporary post, appointments can be substantive. Post may be temporary, but appointment may be substantive. Here, the post is regular, vacant. Post was filled up by following the procedure which was being followed previously, from other cases previously, when filled up, same posts were filled up by following that process, the same process was adopted, giving option to all who may opt for, and thereafter selection was made. After selection, appointment was made. Therefore, post is regular, permanently open vacant post. Appointment was made by following the process of selection. And therefore, the person who was appointed was granted a higher status, higher pay scale. He was enjoying and was discharging the full duties of that post. Therefore, going by the explanations given by the apex court, laying down the law that in such cases, this will be a substantive appointment. Therefore, my response submission is referring to those decisions my learned friend has already placed before your lordship. This is a substantive appointment to the post of protocol officer, and he was holding the post on that date substantively. To that extent, there was no challenge to that post. Appointment, selection was never challenged. Appointment and selection was never challenged. And then came the opportunity of filling the post of Secretary to the Honorable Chief Justice. When this opportunity arose, the post of Secretary to the Honorable Chief Justice was sought to be filled up. So what is the procedure available? The procedure available is that all those who come within the zone of consideration for their post, their cases shall be placed before the Honorable Chief. Is the registry will prepare a note in respect of all the candidates who are eligible to be considered for the post of Secretary to the Chief Justice shall be placed before the Honorable Chief Justice. It was done. While doing that, my case was also placed before the Honorable Chief Justice because I am holding the post of protocol officer. The protocol officer's post comes within the pool of officers who can be considered for the post of Secretary to the Chief Justice. So my case was also placed before the authority. The authority has been granted the power to make a choice. The Honorable Chief Justice has been granted the power to make a choice from amongst all those eligible candidates, whoever he found suitable. From amongst that pool of officers, whoever is found suitable by the Honorable Chief Justice shall be appointed as the Secretary to the Honorable Chief Justice. So this discretion has is vested with the Honorable Chief Justice, the power is vested with the Honorable Chief Justice, and so far the administration, internal administration of the High Court is concerned, he is the master. Then there is no dispute at all. Therefore, the Honorable Chief Justice had ultimately chosen from amongst them this appellant, that he should be appointed as the Secretary to the Chief Justice. Now comes the qualification. He was appointed as officiating secretary on officiating basis. That lordship will see the order 144. Right. 145. 145. Kindly see this, Malad.
145 of the appeal book.
Appeal book, Malad.
Appeal memo.
It says, lordship got it, Malad. I am just placing. In exercise of the powers conferred under Article 229 of the Constitution of India, Honorable the Chief Justice has been pleased to appoint, say, so and so, temporarily and until further orders as Secretary to the Honorable the Chief Justice on officiating basis in the principal seat of the Guwahati High Court in the pay band of rupees such with a great pay of rupees such per month plus other allowances admissible. All that. Then last para, the so and so shall maintain his seniority in his original cadre, that is senior judicial assistant, and his further promotion will be made on that basis.
Because
This line, this particular two lines, might raise a question in the mind. And the lordship asked me that question the last occasion, if I can remember correctly. Whether this indicates that he is still the substantive, holding the substantive post of SJ. Obviously, that will raise a question in the mind. He is now appointed substantively, if he is already appointed substantively in the post of protocol officer. Would there have been a condition of this nature attached to this appointment later? What might be the explanation to this? What is the reason? I am asking myself. What follows in my respect submission is that since I have been taken away from the normal promotional channel to a different line, a cadre which is separately placed, And from there, again, there is no promotional avenue as such to any other post. Therefore, that condition initially maintained, at any rate, these post services are to be judged from subjective satisfaction. And therefore, if someone fails finally to come up to the satisfaction and may have to go back, then in that case, that subjective post shall remain. His position shall remain there. That being the position, again, the same argument that I advanced in case of protocol officer, that will not render the appointment to the post of protocol officer a temporary or purely stopgap officiating. That will be a substantive appointment. That consideration, that validity conferred by law will remain, and the benefit will accordingly accrue to the holder of the post. Now, when this officiating appointment as the secretary, why then this officiating appointment? Lord may again ask me that question. If the post, again, this post of secretary to the Chief Justice is a permanent post, regular vacancy, that was filled up by following the process, by following the procedure which was being followed, holding this position in this honorable court, and registry was following since before.
Who was appointed as secretary to Honorable Chief Justice prior to this person?
Some Chaudhary case. Shailendra Chaudhary, I suppose.
Same procedure was followed.
Then how he retired as secretary to CJ or he was promoted further?
He was promoted thereafter.
As what?
To the deputy registrar.
Post of deputy registrar. Shailendra Chaudhary was,
And just, yes.
he was thereafter promoted to the post of deputy registrar.
Yes. He was thereafter promoted and accordingly the post fell vacant, then his appellant was filled.
Thereafter, this recruitment process to that post took place.
Shailendra?
Chaudhary.
His name has been referred to by the learned single judge. Judgment, including judge.
Lordship will also inquire what post Shailendra Chaudhary was holding prior to his appointment as secretary to the honorable.
He is a grade one stenographer.
Huh?
Stenographer. He was the grade one stenographer that time.
Is that a feeder post to the?
Within that.
Class 2B,
He was class to be
class 2B,
private secretary, grade one.
He was class 2B.
Yeah, he was class to be. It was within the pool.
He was class 2B
yes.
and he was secretary to CJ. also.
Yes.
So
They
he
all-
was in the feeder post anyway.
Yes,
Oh,
feeder
yes,
post,
feeder post.
feeder.
But he also did not possess law graduation. He was also not law graduate.
Therefore, well, all those who come within the,
Anyway, for this, for the post of secretary to Honorable CJ.
Yes.
Protocol officer, this class 2C is a feeder post.
Yes,
yes. We were in the, I was in the feeder post.
2B,
Therefore-
class 2B and 2C in the feeder grade.
Class two AA,
Class
B
two A,
and 2C.
2C, I belong to
Three
2C.
three categories.
2A, B and C.
C.
Rule 738.
Rule is 7-3.
Rule 7, Chapter 3.
Yeah, that's it. 7-3. 63 years of relaxation power. And it is more put.
So, Rule 7(3)A of the High Court Services Rules 1967 is very relevant. What you will find, it says,
When that Shailendra was promoted to secretary to CJ, was the same condition there in his appointment? No.
I don't. Well,
এই যে আমার যেটা দিছে যে his original seniority will consider in his original cadre. এই যেটা কিবা আছে।
Is it there?
No.
Yeah.
Because you are already holding a certain.
It is not there.
Lordship will kindly see.
No, no, in our case, my lord,
Again,
no, in our case, officiating appointment তো ঠিক আছে,
no, no,
কিন্তু যেটা রেগুলার করছে সেটা মানুষের নাই তো।
no, particular. Lordship is asking whether Shailendra Chaudhary while appointed as a protocol officer,
Secretary to CJ.
secretary to CJ, then this condition was not there. This condition was not there. I was appointed on officiating capacity. That's how this came in. Because my substantive appointment remains as the protocol officer.
Were you regularized as a protocol officer?
Then no, not, that is why I say, there was no question of regularization. I was substantively appointed. There was no question of regularization. They are trying to make a case that since his appointment was followed by the condition that he will maintain his seniority in the original cadre while being appointed as protocol officer, therefore it is temporary. To counter that, our argument is that these two lines indicating his seniority in his original cadre is not relevant considerations to judge whether the appointment was substantive, regular, or the person was holding the post substantively on regular basis. That has to be seen.
Any other things are in.
That has to be seen otherwise. Not with that. Now it has come out from the horse's mouth also. The High Court has explained it. That this was kept only for the future contingency. Otherwise, the appointment is substantive, regular.
What do you mean future contingency like?
That is, if he is found at a certain point of time wanting for the efficiency, then he might be sent back. And therefore, these are the jobs which are onerous, carrying risk, and he will have to discharge to the satisfaction of the authority. And therefore, everybody doesn't opt for. Therefore, the option was given by few limited persons. Normally, well, such things, such posts are to be taken only by those who take a risk. Everybody may not like it. Therefore, well, my response submission is that his posting, High Court has explained it, that his posting was regular and substantive. So far, his appointment as protocol officer is concerned, he was a member of the service. He was a member of the service. If he was a member of the service, he is entitled to have the benefits of service emanating from the service rules, all benefits, and he is entitled to. That's how his case was placed. For considering for the post of Secretary to the Chief Justice. In page 9
Of the judgment.
of the judgment, Lordship will kindly turn to at this moment. This is Arun Roy's case, my lord, Arun Kumar Roy.
Acha, this, your booklet,
Yeah, okay.
Booklet, my lord. Kindly come to the booklet now.
page 9,
Page 9,
yes,
paragraph 18. Let us read slowly, my lord.
citation table.
Citation to Union of India versus Arun Kumar Roy. 1986, 1 SCC. Page 675. Paragraph 18 and
The question whether the terms embodied in the order of appointment should govern the service conditions of employees in government service, or the rules governing them is not an open question now. It is now well settled that a government servant whose appointment, though originates in a contract, acquires a status and thereafter is governed by the service rules and not by the terms of contract. The powers of the government under Article 309 to make rules to regulate the service conditions of its employees are very wide and unfettered. These powers can be exercised unilaterally without the consent of the employees concerned. It will therefore be idle to contend that in the case of employees under the government, the terms of the contract of appointment should prevail over the rules governing their service conditions. The Supreme Court has nullified it. The origin of government service oftentimes is contractual. There is always an offer and acceptance, thus bringing it to being a completed contract between the government and its employees. Once appointed, a government servant acquires a status and thereafter his position is not one governed by the contract or appointment. This is the principle followed by. Public law governing service conditions steps in to regulate the relationship between the employer and the employee. His emoluments and other service conditions are thereafter regulated by the appropriate statutory authority empowered to do so. Thus, regulation is permissible in law unilaterally without reciprocal consent. This court made this clear in two judgments rendered by two constitutional bench of this court in Rosenlal Tendon and State of J&K. Thus, it is clear and not open to doubt that the terms and conditions of the service of an employee under the government who enters service on a contract will, once he is appointed, be governed by the rules governing his service conditions. It will not be permissible thereafter for him to rely upon the terms of contract which are not in consonance with the rules governing the service. Therefore, my response submission is, when in the rules, the protocol officer, providing for protocol officer, there is nothing like one can be appointed with such a rider of asking, providing for maintaining its seniority in the lower cadre. And it speaks about the substantive appointment. And this is how the appointment procedure was made. And this is how the appointment was made, following that procedure. Therefore, this condition, although included, having not given effect to and have no otherwise operational value.
So could it be said that though the words or the conditions stipulated in the order would imply that his seniority would have to be counted as an SJ, the post of protocol officer being an NCADET post, his appointment after proper selection in terms of the resolution passed by the High Court, which amounts to basically an executive instruction, which is akin to an executive instruction, cannot allow the appointment of the appellant in the manner it has been done.
Yes, it would
I
not
think
have been done.
that is what you're trying to say.
That could not have been done. Notwithstanding that, even if such a condition is included, but ultimately, the conditions in the rules, conditions in the service conditions mentioned in the rules, and going by the nature of appointment, that will prevail. That will prevail. Post the protocol officer appointment or it was not.
Yes, one thing, Mr. Parwari, what he's trying to say, I believe, is it is an NCADET post.
Right.
So, though there might have been an attempt to say promote him to that post, keeping his substantive post in SJ protected. The fact that the post of protocol officer is an NCADET post, the order promoting him in such a manner was not, would, cannot be sustainable. And it would have to be considered to be a regular promotion.
So he ought to have challenged it before appropriate forum. In my writ petition, as an OP, can he claim that relief?
Huh?
In my writ petition, as an OP, can he claim that relief, my lord? He ought to have challenged it if he has agreed, my lord. It was his appointment. If it was detrimental that the rider, then he had to get it clarified by this honorable court by challenging it.
My lord, my
And-
instant reply would be, I could not have the bargaining power. I was given an appointment, I joined. Law says it is the service conditions that will thereafter will operate. So therefore, I'm protected from that side, not by the condition mentioned in the appointment letter. Notwithstanding that, nothing has been done by this honorable court, I mean the registry, against my interest, even except putting that line, which was never given effect to. Was there any occasion for me to challenge it? No. There was no occasion for me to challenge it. Legally, this has no implication. Once I was appointed substantively in the post of protocol officer, because I am entitled to all the benefits emanated out of the rules, all benefits I was given. I was given full benefit. My case was considered, taking me as a substantive appointment by the registry for the next higher post of Secretary to the Chief Justice. So this did not result in the adverse consequence to me. Had there been any, it is always open for the employee to challenge it at any time. Supreme Court says that such conditions can be challenged at any time if it comes to be operated against him. My absence, firstly, am I capable of bargaining? No. No. I have been given an appointment, I have accepted it. Therefore, when this particular condition has not been applied at all, given effect to, and it has not resulted in a prejudice to me, why should I go against it? Now they are taking shelter to that particular condition to argue that no, my appointment is temporary. Whether that construction is permissible, that is the point your lordship will have to consider. Learned Single Judge has taken their point and considered it to be a temporary appointment. In my response submission, this is not fair, not proper, not just, and not legal construction of the appointment order. It is not the question of my not challenging. It is now the question whether interpretation sought to be given by the petitioner to that particular 2 lines of my appointment order can be sustained or is it correct? And whether to that context, the finding of the learned single judge that this is a temporary appointment can be held to be just and fair and legal. In the factual context of the entire development leading to the appointment.
Just to verify, my lord, if my lord and senior permits. My lord, the issues involved in the list when we find the writ petition was not regarding the appointment as a protocol officer. Subsequently, the same rider was there when he was appointed in officiating capacity as Secretary to Honorable Chief Justice. And subsequently, that officiating order of officiating appointment as Secretary to Assembly was challenged. Subsequently, he was regularized, my lord, by condoning the qualification prescribed by the rules, that is law degree, and that was also subsequently challenged. This is what the learned single judge was interpreted, not the appointment as a protocol officer. So if that rider in the appointment as protocol officer was honest, was not of any consequence, then why then again the same rider was placed when he was appointed as an officiating capacity as the Secretary to the Honorable Chief Justice? That has to be looked into, my lord. if he was a substantive appointee as a protocol officer, same rider, when he was appointed as officiating capacity, as honorable, he was seniority maintained as SJ. Lordship will kindly see the rejection list, see that serial number 45,
After the officiating promotion,
as secretary to the honorable chief
as
justice.
secretary,
That was challenged.
that was regularized.
During the pendency, my lord, he was regularized. Then again, we shall file the second petition.
And in the regularization, that thing is not there anymore.
No, it's not. So the question arose, my lord.
Anyway, so yes, so
That's how the question arose, because they say that since I was considered for the post of secretary to the chief justice, which could not have been done, because I was not holding it substantively, I was a temporary employee to the post of protocol officer. That was their case. And to that extent, the learned civil justice said, yes, it was a temporary appointment, rather promotion. But fact remains that we should not confuse a post which is open for promotion and a post which is not open for, rather it was meant for direct recruitment. Here it is a post which was open for direct recruitment, not for promotion. Therefore, these connotations have differences, and little difference will create vast difference. If my appointment to the post of protocol officer is constituted to be a substantive appointment, then I acquired the right, and the authority has rightly placed my case for consideration before the chief justice for the promotion, for appointment to the post of secretary to the chief justice.
anyway, so how much time 1 hour is going to end?
Yes, my lord, therefore, because that was the point where we required little deliberation, so lordship has taken the grip of the whole facts now. Now I can straightway go to the law point. Therefore, the question is, when I am eligible to be considered for the post of secretary to the chief justice, I was considered and I was appointed. I was chosen. I was selected and appointed. But while being appointed, it was made an officiating arrangement. I was allowed to work only on officiating capacity. That means that was not a regular subsidiary appointment.
Secretary.
For the post of secretary. Lordship will see that order. That order is there. 145. 145. Just the এখানে refer করে ফেলে দিলাম. This is the order, my lord. In exercise of the power conferred under Article 227, the Constitution of India, Honorable Citizen will please to appoint so and so temporarily and until further orders. This is purely temporary and until further orders. As Secretary to the Honorable Chief Justice on officiating basis. Officiating basis with higher pay, grade and everything on officiating basis. Now, this appointment was on 10th of September 2018.
Again, that condition is there.
Again, that condition was there. It was temporary officiating capacity. So all conditions that follow. Then I was considered for regularization and my appointment was regularized. Next page, lordship will find page 146. It says, in exercise of the power so and so, read which Rule 63A, which provides the power to relax. 63A of the Honorable Guwahati High Court Service Rules 1967, Honorable Chief Justice has been pleased to regularize the appointment of so and so as Secretary to the Honorable Chief Justice with effect from 4/7/2020, which was made video registered notification number so and so dated 10/9/18. This is my regularity. So they initially filed a petition challenging that officiating appointment as secretary, and then second petition as the secretary regularized after regularization. Now, what is the illegality here? Fact remains that the authority to make such order is the Chief Justice. Power of the Chief Justice has not been denied. That has not been disputed. Chief Justice has been given the power to relax. I was not having the degree of law. Question is, notwithstanding that, whether I could have been considered for appointment as officiating secretary. In my response submission, it is always suggested, it is always rather emphasized by these courts also and the apex court that whenever the process is followed, the process should be a fair process for selection and appointment. For the post of secretary, initially, what was the process followed? As I have already submitted, the cases of all the eligible candidates coming within the pool of consideration, zone of consideration have been placed before the Chief Justice. Chief Justice selected me. I was not having the law degree. Where there are other qualified persons, questions may be raised. Qualifications, maybe.
No, you see, we are of the tentative view that the Chief Justice has the power
Yes.
to, and the discretion to, and
Yes.
I do not think that it would be proper for
Yes.
another judge to, the court to substitute its views,
Exactly, but I'm grateful.
especially since it is a subjective issue.
Exactly.
However, the issue that has to be basically decided here is whether the promotion as protocol officer was a regular promotion. And that will decide the issue. So it's whether the promotion was regular or not.
Appointment,
Appointment.
Yes.
Appointment.
appointment.
If the appointment is by way of what? It's a direct appointment.
Yes, direct appointment. Not by way promotion.
Direct appointment.
Yes.
Election was made.
And from
After-
from protocol officer to secretary to CJ, that is again, what is that?
Again, this is the procedure followed.
That is promotion, or that is the direct recruitment. What? So there are two direct recruitments.
There is, well, there is two direct recruitments. The law provides, the rules provides that all these officers are eligible to be considered for the post of, not that they are
So one direct recruitment after the other.
one. Well,
One direct recruitment after the other. So for
Yeah.
protocol officer, is it a promotion or a direct recruitment?
By the submission to the post of protocol officer, it is a direct recruitment. From the post of protocol officer to the post of secretary to the Chief Justice.
Is again direct recruitment.
Exactly. Exactly. This is how the rules provides. Therefore, my lord, there is no option. Question is, nobody has challenged that procedure. Nobody has challenged that procedure. No challenge has been put to such rules or that procedure, that the procedure itself is bad or arbitrary.
Except the rule as of now.
Therefore,
Maybe bad.
Therefore, the procedure which was being followed that time, the procedure which was adopted and followed that time, the only procedure which should be accepted as valid. And within that given procedure, whether the things were done fair. Because here, malafide is not the point. Malafide do or less, they have not pressed it. Malafide is not the point. So what remains then? Arbitrariness, procedural violation, injustice. Lordship will kindly consider when these considerations are raised, now so many petitioners, 3 petitioners, none of them were qualified, only except 2 ladies. We have checked out. Only except 2 ladies, others were not having qualification. But the Honorable Chief Justice considered it. And having found the most suitable, because here the mere eligibility and qualification is not enough. It is the suitability. Suitability of the rules. Can you see? Suitable. 738. Rule 738 says, Mala, in my that booklet, Lordship will find paragraph page 3. Column C, we have quoted it.
What? Page 3.
Page 3,
Written argument.
written argument.
Page 3. The rule 738 has been quoted. Okay.
Yes. Column C. And Lordship will find 738 we have quoted. The secretary to the Honorable Chief Justice shall be appointed from amongst the gazetted
What
officers.
about appointment to the post of protocol officer?
Protocol officer,
Any rules?
No specific rule.
It is by the Judges Committee resolution.
Judges committee has decided that this is how this
What does the committee say?
committee said, আসলে কিবা তোমারটা? But if I can remember correctly, as the submission was made last time, that the options should be invited, called for from these categories of employees, and from among them selection should be made. And this condition was asked to be there, that he will have a maintained seniority in the
See, the resolution was that options may be called from the willing as double SA for the post of protocol officer and from willing JWS for the post of assistant protocol officer.
Committee, High Court committee resolution dated?
This is 24/3/2014. Office note on my.
Resolution dated 24,
3/2014.
24/3/2014.
Lords, we find this in a convenience compilation I gave it to you Lordship of the records. There you also will find this detail.
There's so many documents have been given to us. We don't know which is.
Small two compilations I have given 3-4 pages. One is with regard to protocol. officer.
Convenience compilation, this is
Yes.
the one.
Yes, one is with regard to protocol officer and another is with regard to
Secretary.
Secretary.
Wait a minute, these notes.
Yes. Lordship will have the page number from the records and the dates also. I have checked I have incorporated the page number from the records.
Anything else? Yes.
So that being the position, my report submission is, Lordship has seen here, it is the having a degree in law considered suitable by the citizens. So suitable, mere,
No, that is a different aspect. Now,
Yes.
I think we've already spoken our mind on that.
my lord. Therefore, to our best, I tried to explain our position and cite also the reasons, if Lordship will be pleased to accept it, that my appointment to the post of protocol officer is a substantive appointment. There is no way out to construe otherwise. And therefore, the rest follows, and there is no illegality or arbitrariness in appointment. And judgments, my lord, we have already cited that Arun Kumar's case. Then,
It is 11 Act, page 11.
Isn't this enough? Or there's some more?
No, it is
No.
not.
This is enough.
Everything is there.
everything we have mentioned.
You have
here.
cited this. You have cited.
Yes.
rejected.
One more judgment I would like to show the lordship pleases.
Yes, that is, Rajasthan.
Rajasthan High Court judgment for persuasive purpose, the lordship would like to see.
Well, Rajasthan High Court, this decision is Lordship may kindly consider.
You all have given us so many decisions. We don't know who is who though.
No, my lord, that binding compilation is ours. We have printed our names and appellants.
Okay, this is from you,
Yes. Appellants,
from Niroj Sharma.
Niraj Chandra.
And this
Para?
additionally, we are giving
No, this
Para
High Court, Rajasthan High Court, para.
Para 10 million.
There are 10 Lordship will kindly come to. There are 10. The order of the then Chief Justice was challenged on the ground of being malafide, but practically all allegations on that point were withdrawn. The argument addressed was that the then Chief Justice exercised his power arbitrarily. Now, it should not be forgotten that the Constitution makers in their wisdom conferred the power of making appointment in the High Court on the Chief Justice. This power has been entrusted to the safe custody of the Chief Justice in order to ensure the independence of the judiciary, which is one of the vital organs of the government. In the long history of the High Court in India, this power has always vested in the hands of the Chief Justice. Clause 10 of the Charter of the Supreme Court of Calcutta, issued in 1774, authorized and empowered from time to time to appoint as many as such clerks and other ministerial officers as was found necessary for the administration of justice. The Constitution has also recognized that in the internal administration. in this order of appointment, it cannot be said that there was any arbitrariness in this matter. Even under the rules, the post of the assistant registrar was a selection post, and the then Chief Justice was entitled to pick and choose the best man from the thought which he thought fit to appoint on that post. However, we cannot substitute our own judgment from the judgment of the then Chief Justice. The Constitution has entrusted that duty to him. He has exercised his own discretion. It is a case in which an administrative authority has exercised its own discretion. And even if we take a different view of the matter, we should not substitute our own views in place of the views of that authority. As observed by the lordships in the Supreme Court in Register of Trademarks and Ashok Chandra quoted.
No, it's okay, this is all right, this is
Yeah,
on
so-
this is on the discretion of the. chief
Exactly, my lord, this is what it said, that we cannot substitute, and this power is vested, there is no
Justice. Supreme
arbitrariness.
Court has said many times.
No substantive appointment to দেখা যায় বাকি কাম করে কোন আছে এইটু 11F to দেখাও কোনো এটা আমি পয়সা নাকি
Yes, these citations that you have now given, you have compiled.
Yes.
You have given us 50 citations.
No, we have given by 15, 1 5.
Ah, 1 5, there is no joke. No,
But we have marked the paragraphs, just lordship.
where is the paragraph mark? There is no
Yes, yes,
paragraph mark.
This there in my written argument, my lord, lordship.
Now, where is, where is the written argument? Now, where?
Yes, kindly see page 6 of my written argument. Kindly
Page 6 of your written argument.
Yes.
Ah,
Kindly see the
Okay.
just mentioned paragraph I have marked here.
okay.
Just lordship has to go through one. It's-
I've got to go turn.
If
Give me a
also-
lot of work.
I will mark there. also.
You see what you do is,
So I'll do it, man, right now.
what you do is, in these out here, you just mark the paragraph, just write the
What-
paragraph
what
number.
some Honorable judge
Like-
does not like to.
Just out here, you put the paragraph number.
Yes,
that's all. Otherwise, again, we've got to
Yes,
compare,
yes,
contrast.
No,
all
but
that.
you- well, some courts does not like if it is marked. That is why I done.
Well, they have left us no choice. There are 15 judgments.
I'll
I-
give it, I will do it right now. 2 minutes.
I-
In
If
2
you,
minutes.
if you had given us 1, 2 judgments, okay. You've given us 15. Now he has given us how much? He has given us how much?
Well, a substantive appointment, in case of substantive appointment, if lordship goes for that judgment, it's clearly spelled out. I'll just mark it.
That will be indicated. my lord.
Now,
That is there.
so you have given us this Rajasthan judgment and
Ah.
this
I got it.
compilation.
That's it, man.
Okay, now just give it to them.
I'll do it right now.
Yes.
May I
So,
use the rate?
And what is this, this again, this Supreme Court judgment, what is this? What
That
denotes
is
that?
referred in that Rajasthan High Court. judgment.
That is already referred to the Supreme Court and quoted, Rajasthan High Court quoted that order.
Rajasthan High Court quoted this Supreme Court judgment.
Yeah,
That is why-
Para,
Para
Yeah.
7.
para 7.
Yes.
You just write the
Yeah.
paragraph.
May I use red ink or red pencil?
You use whatever. As long as it's readable.
Yes, I'll do it right now.
So I think, my lord, that will cleanse this.
My friend,
Yeah, you have given, while you enjoy Bihu, I'm going to be pouring over, we're going to be pouring over these papers.
Lordship may take,
Then,
its own
any other judgments? No other
no,
judgments?
no, that,
Yes,
Well, we have already given some judgment,
yes.
but for your lordship of company and for the I can compile it and
Better, I think. Otherwise, we don't know. There's so many loose papers here. It's full of loose papers.
we have only given 4, 5 judgments.
Otherwise, you can take it here.
Take it
You
as
can take this and just
compile.
compile which one is yours.
Yes.
Because he has also given a lot of, now which is yours? I don't know. This is yours. Who has given this? This is another.
Compile.
No, they just give them and let them take the papers and give me a compilation. Huh. You take this, give it to them.
ours are in compilation except that Rajasthan High Court.
No, yeah, Rajasthan and Supreme Court.
Yes, yeah, otherwise, all are in compilation.
No, let them do it, let them give me.
Ah,
We won't write.
Actually,
You have to go, huh?
তুমি এইটা দিয়ে
What time? No, no, just segregate yours, just take away your judgment. Just take away your judgment.
কি বুঝতে পারছেন তার হিসাবটা কেমন
এখানে তো ভালো কথা, ভালো কথা, ভালো কথা।
এটা আমার নাকি আগতে বিশ্বাস এটা লয়ে না এটা আগতে হয় না এটা এটা আমার এই দিচ্ছি দিয়া এটা
I
ওর
only gave Milord this note,
Whatever, just take out that note.
15 hours.
এখানে আমার রেকর্ড করা
বাইকটা বাসি দিয়া ভালকে এখানে আমি আগতে রিপোর্ট হতাম কম্পাইল করে দিয়া হলো না
Okay, you're, read Mr. KK, heard Mr. KK Manta. Learned senior counsel for the appellant, assisted by Mr. A. Chamwa. In WA number, five of 2023. Also heard Mr.
HK Das.
H.K. Das, learned counsel for the appellant. No,
In item,
in five.
in five respond.
Counsel for the point number,
Respondent number, because of, I'll just give. Twenty-one, 22, 23, 24. 21 to 23.
21 to 24.
21 to 20.
In WA number five of
Five.
23. Also heard Mr.
Taking point over.
J. Patwari,
Right.
learned counsel for the respondent number
And then
in five, in five.
Yes. I am for the petitioner. Already,
respondent here
already responded. We are.
For the writ petitioners in WA five of 23. And who is the appellant in the other case?
The detail in 71, I am the applicant.
That's what I've said, no. Heard Mr. What was his name?
HK that.
H.K. Das, respondent number 22, 23, 24 in WA five of 23 and the writ appellant in WA number 17 of
71 of 2023.
71 of 2023. Okay. Then hearing concluded, judgment reserved.
My lord, I have got the records of both the posts, my lord, protocol officer and secretary. My lord, lordship can have a look.
But give it to me, I don't know if
I have given the compilation also, my lord, wherein your lordship will get the page numbers of from the records.
Is this the one?
Yes, that is for secretary, this is for protocol officer, my lord.
This is for secretary.
Along with, in the previous hearing, your lordship was pleased to get some photocopies from the records. Those are also there, few pages.
then in that case lordship can just go to that only photocopy need not have to open the files
Yes,
No,
yes.
all are not there, my lord. All are not there. If something is required, then it's there in the.
this is for protocol officer.
Lordship, along with that, Honorable Judges Committee's resolution 2014, which my learned colleague has just referred. Lordship will also see the resolution dated 9/3/2015. 9/3/2015, 9th of March.
Just a minute, 9/3, yes.
Lordship will peruse that also. And I have taken out the judgments, my lord, and give a comparison in Friday, I will submit.
Friday, what do you mean Friday?
The tomorrow, my lord.
Yeah. So this can be kept with me. Okay, then this will be kept with me. This is by High Court. This is by High Court. He is marking that. Only that is, and you,
I have taken out the judgment. I will make a compilation.
yes, and just mark the
But
Paragraph.
I understood.
He will by tomorrow evening.
I will give him after that.
Records I'm giving to, for.
How thick is it? How thick it is?
No, but I have tried to help you also by marking the pages there.
I'll have to, I need the petition and this five, I think.
Five.
WA five is enough, I think.
Yes, yes.
I don't think,
Five is
I don't think I need any other.
Identical, only the appendix
So
different.
no need of that, yeah, no need of that. Huh? No need.
If any point of time your lordship finds requirement, then
Yeah,
Raise
then
it
I'll
for
tell
the-
him.
yes.
I'll tell him to get it from.
Yep, yep.